Good morning and welcome to the Public Service Commission of South Carolina. It is Wednesday, July 21st, the date of our regular business meeting. However, we are at a special time this morning because we have some items to follow up after this meeting, or a continuation of this meeting. I would ask that let's take a roll call of commissioners first. Present in the hearing room, we have Commissioner Thomas, Commissioner Powers, Commissioner Carol Lee Williams, Vice Chair Belser. Present virtually, we have Commissioner Caston. I see two Commissioner Castons. I heard Commissioner Irvin earlier. Is he on the line? There's Commissioner Irvin. Anyone else?
Vice Chair Belder, Chairman Williams is also on the call.
Okay, thank you, Chairman Williams. Didn't realize you were going to be on the phone and not visible, and that's fine, but thank you. So we have all commissioners present, either in person or virtually. I would ask that you join me for a moment of silent reflection before we get in the meeting. Thank you. Mr. Butler.
Thank you, Madam Vice Chair. Good morning to you and the rest of the commission. The first order of business would be to set the next commission business meeting, and staff would suggest Wednesday, July 28th at 11 a.m.
That's next Wednesday at our regular time. Is that correct?
Yes, ma'am, that'd be correct.
That's fine. Thank you very much.
All right, thank you. We do have a supplemental agenda item. This is in docket number 2021-88E, and there is a motion for extension of time and motion to continue the hearing.
Supplemental agenda item 1. Do I hear a motion from anyone?
Madam Chair,
Commissioner Powers.
I move the commission grant the following new pre-filing dates. All other parties, July 27th, 2021, rebuttal August 10th, 2021, rebuttal August 16th, 2021 by 2 p.m.
I can't hear.
Okay, just a moment. Commissioner Powers, can you pull your microphone a little closer?
Sir.
And in the back, do we have any control over that volume? If we could turn him up a little bit. Commissioner Powers, would you mind starting over, please?
Thank you. I'll repeat it then. I move the commission grant the following new pre-filing dates. All other parties, July 27th, 2021, rebuttal August 10th, 2021, rebuttal August 16th, 2021 by 2 p.m. I also move the commission deny the motion for continuance of the hearing in this matter. I so move.
Thank you, Commissioner Powers. Commissioners, you've heard the motion. Are there any questions or any discussion? Hearing none, we'll proceed to a vote. Commissioner Powers?
Aye.
Commissioner Carol Lee Williams?
Aye.
Commissioner Caston? Commissioner Caston? Commissioner Caston, can you hear me? Commissioner Caston, can you hear us?
Jocelyn, I can't hear any.
Okay, Commissioner Caston, we hear you on the phone now. Do you hear me?
Can you hear me?
Commissioner Caston, we can hear you on the telephone. Commissioner Caston, can you see if your computer is muted? And ladies and gentlemen, I'm going to ask your indulgence, please, and we're going to stand in recess for just a minute while we get this this glitch cleared up. Commissioners, please stay on the line, but we are going to be standing at ease for just a moment. Good morning again. We are back at the Public Service Commission business meeting. I apologize for some technical difficulties. We hope to have those straight now. Just to be clear, let's go ahead and do another roll call of commissioners. Virtually, we have Commissioner Irvin, Commissioner Caston. Telephonically, we have Chairman Williams. Present in the hearing room,
Here.
Present in the hearing room, we have Commissioner Thomas, Commissioner Powers, Commissioner Carol Lee Williams, and Vice Chair Belser. And I recognize Mr. Butler. Well, if I may, excuse me. Commissioner Caston, did you hear the motion that we were voting on? Supplemental Agenda Item 1?
No, ma'am, I did not.
Okay. Commissioner Powers made a motion. I'm going to ask Commissioner Powers to make his motion again, and we will just start anew. Thank you.
Madam Vice Chair, my motion was I move the commission grant the following new pre-filing dates. All other parties, July 27th, 2021, rebuttal August 10th, 2021, surrebuttal August 16th, 2021 by 2 p.m. I also move that the commission deny the motion for continuance of the hearing in this matter.
Thank you, Commissioner Powers. Commissioners, you've heard the motion on supplemental agenda item 1. Are there any questions or discussion? Hearing none, we will proceed to a vote. Commissioner Powers?
I vote aye.
Commissioner Carol Lee Williams?
Aye.
Commissioner Caston?
Aye.
Commissioner Irvin? Commissioner Irvin? Commissioner Irvin, can you hear us? Do we have Commissioner Irvin?
I'm
Vote
vote aye.
aye.
Thank you, Commissioner Irvin. Commissioner Thomas?
Aye.
Chairman Williams?
Aye.
And I vote aye as well. The motion passes. Mr. Butler, next item, please.
Yes, Madam Vice Chair. Moving on to the Commission's Utilities Agenda. Item number 1 is in docket number 1999-132C, and this is a request of One Tone Telecom Incorporated to cancel its certificate.
Commissioners, is there a motion?
Madam Vice Chair,
Commissioner Thomas?
I move that the commission grant the request of One Tone Telecom Incorporated to cancel its certificate of public convenience and necessity and for withdrawal of its tariffs.
Thank you, Commissioner. Commissioners, you've heard the motion. Any questions or discussion? Hearing none, we will proceed to a vote. We'll start with Commissioner Thomas.
Aye.
Chairman Williams?
Aye.
Commissioner Powers?
Aye.
Commissioner Carol Lee Williams?
Aye.
Commissioner Caston?
Aye.
Commissioner Irvin?
Aye.
And I vote aye. The motion passes.
Madam Vice Chair, other members of the Commission, item number 2 on the Utilities Agenda is in docket number 2021-224C. This is the petition of MCI Metro Access Transmission Services Corporation, DBA Verizon Access Transmission Services, for review of the pooling administrator's denial of its application for numbering resources in Columbia, South Carolina.
Commissioners, you've heard the agenda item. Is there a motion?
Madam Vice Chair,
Commissioner Thomas?
I move that the commission reverse the decision of Somos Gov. Inc., the pooling administrator, that denied the application of Verizon Access for one contiguous 1,000 block of telephone numbers in the Columbia, South Carolina rate center. I further move that the commission order that 1,000 block be assigned to Verizon Access in the Columbia, South Carolina rate center. So moved.
Thank you, Commissioner. Commissioners, you've heard the the motion. Any questions or discussion? Hearing none, we'll proceed to a roll call vote. Commissioner Powers.
I vote aye.
Excuse me. That's fine. Commissioner Powers.
Aye.
Commissioner Carolee Williams.
Aye.
Commissioner Caston.
Aye.
Commissioner Irvin.
Aye.
Commissioner Thomas.
Aye.
Chairman Williams.
Aye.
And I vote aye. The motion carries.
Item number 3 is in docket number 2006-401G, Madam Vice Chair. And in this case, staff presents for commission consideration a correction to commission order number 2021-470.
Is there a motion?
Madam Vice Chair, this is Commissioner Caston.
Commissioner Caston, please proceed.
I move that the commission issue a correction to commission order number 2021-470 dated June 30th, 2021 as follows. Omit the sentence that states a typical residential customer using 100 therms in a month would see an increase in the bill from $90.11 to $100.18, which is an increase of $10.07. Replace that sentence with the following. The typical residential customer using 100 therms in a month would see an increase in the bill from $90.11 to $100.29, which is an increase of $10.18. The remainder of the present language in order number 2021-470 would remain the same. I so move.
Thank you, Commissioner Caston. Commissioners, you've heard the motion. Any questions or discussion? Hearing none, we'll proceed to a roll call vote, beginning with Commissioner Caston.
Aye.
Commissioner Irvin.
Aye.
Commissioner Thomas.
Aye.
Chairman Williams.
Aye.
Commissioner Powers.
Aye.
Commissioner Carolee Williams.
Aye.
And I vote aye. The motion carries.
Item number 4 is docket number 2021-4G. At this time, the case of Piedmont Natural Gas Company Incorporated's annual review of purchase gas adjustment and gas purchasing policies is ready for final disposition.
Commissioner Irvin, I believe you had to miss this meeting, and so you have recused yourself. Is that correct?
Correct. That's
Thank,
correct.
thank you. Is there a motion on this matter?
Madam Chair,
Commissioner Powers.
thank you. I will move that the commission find Piedmont Gas purchasing policies and practices during the review period to be reasonable and prudent. The company properly adhered to the gas cost recovery provisions of its gas tariff and commission orders. The company managed its hedging program in a reasonable and prudent manner consistent with the commission orders. The end of period balance for Piedmont's hedging account and deferred gas account are reflected in the testimony and evidence as presented at the hearing. In follow-up to Commissioner questions and witness testimony about whether the company purchased natural gas from green producers that reduce the impact of national gas production on the environment, I move that the clerk's office open a separate docket for the purpose of reviewing and exploring the gas purchasing policies and practices of Piedmont Natural Gas Company Incorporated and of Dominion Energy South Carolina Incorporated. This new docket would review and examine the feasibility for options to consider gas purchasing policies and practices related to reasonably sourced gas purchases, as well as any financial impact on customers and costs. The Commission staff is directed to establish a procedural schedule allowing for participation by interested parties or stakeholders, as well as to provide for written comment or report by each gas utility concerning RSG purchases, percentage of overall gas purchase, impact on rates and costs, and other related matters. I so move.
Thank you, Commissioner Powers. Commissioners, you've heard the motion. Any questions or discussion?
Madam Vice Chair,
Commissioner Thomas.
thank you. I would offer a friendly amendment to the new docket. The term reasonably sourced gas, or RSG, should be responsibly sourced gas.
That is accepted.
Thank you, Commissioner Thomas, and thank you, Commissioner Powers. Hearing the amended motion, any further discussion or questions? Hearing none, we'll proceed to a roll call vote. Commissioner Powers,
I vote aye.
Commissioner Carol Lee Williams, Commissioner Caston,
Aye.
Commissioner Irvin,
Aye.
Commissioner Thomas,
Aye.
Chairman Williams,
Aye.
and I vote aye. The motion as amended carries.
Yes, Madam Chairman, other members of the commission, item number 5 is in docket number 2019-224E and 2019-225E, the two Duke IRP cases. And this motion is to hold the integrated resource plan update requirement in abeyance in those dockets, and also to request a limited clarification of order number 2021-447.
Thank you, Mr. Butler. Commissioner Carol Lee Williams, I believe you are recused on this matter.
That's correct.
Thank you very
Madam Vice
much. Commissioners, do I hear a motion?
Madam Chair,
Commissioner Powers.
thank you. Duke Energy's Carolinas LLC and Duke Energy's Progress LLC have filed a post-hearing motion or petition which requests that the company's 2021 IRP update be held in abeyance and for clarification of order number 2021-447. The motion by the companies amounts to a petition for reconsideration, and it should be treated as such. I move that the commission grant the motion or petition to hold the filing date for the company's 2021 IRP update in abeyance, and that such abeyance be held until December 6, 2021, at which time the companies must file a 2021 IRP update. I would further move that the commission clarify order number 2021-447. The order contains a scrivener's error in ordering clause number 19. The language by SEBA witness Lucas is incorrect, and the language by ORS witness Cullen is intended. Ordering clause number 19 should read, in future IRPs, including modified IRPs and IRP updates, Duke shall perform and include a mini-match regret analysis of the type described and performed in this proceeding by ORS witness Cullen. I so move.
Commissioners, you've heard the motion. Any questions or comments?
Vice Chair Belzer, this is Chairman Williams.
Chairman Williams, please go ahead.
I'd just like to point out that in a perfect world, we would not have to, companies would not have to ask for permission to hold this matter in abeyance. But we are trying to do our best, and I think all parties involved are trying to do their best when it comes to meeting the deadlines, various deadlines in Act 62. My hope is that at some point we get on track where we can, companies can make their filings and we can hear these cases in a manner that won't require them to ask for continuance, or in this particular case, abeyance to the filing date. So, that's going to take work on the commission's part, and it's also going to take work on the parties' part. But I just want to let everyone know that I'm committed to making sure that we can stay on track and meet these deadlines as the statute intends. Over.
Thank you, Chairman Williams. I agree that the timing presents some challenges at times, and the parties have graciously and worked with us as well within as they can, and so I definitely agree with you. And it's a new thing for us. We've never had to have contested hearings on the IRPs, so I think we're learning as a commission, and I think the parties are learning too, and we just appreciate everyone's patience and flexibility. But I do appreciate your comments. Any other comments? Then we'll proceed to a roll call vote. Commissioner Powers,
I vote aye.
Commissioner Carol Lee Williams, you are recused. Commissioner Caston,
Aye.
Commissioner Irvin,
Aye.
Commissioner Thomas,
Aye.
Chairman Williams,
I vote aye.
and I vote aye as well. The motion carries. Mr. Butler, before you go ahead, we need to go back to item number 4 briefly. And Commissioner Irvin, I need to apologize to you because we had noted that you were recused, and then I called you for a vote anyway, and I apologize for that. But let's just make the record clear that you do not intend to vote on item number 4. Is that correct?
That's correct.
Thank-
Let the record reflect that I did not vote. I was on family leave and was not present for the hearing, so the records reflect that I did not vote. Thank you.
Thank you, Commissioner Irvin, and I apologize. I should not have called on you for a vote.
problem.
But thank you very much. Let's see, Mr. Butler.
Yes, Madam Vice Chair and other members of the commission. Item number 6 is in docket number 2021-88E, but in light of the commission's vote on supplemental agenda item 1, staff would recommend that this item be carried over.
That item is carried over. Thank you.
Okay, thank you. Item number 7 on the agenda is the proposal for final disposition of Duke Energy Carolina LLC's application for approval of demand-side management and energy efficiency rider 13, decreasing residential rates and increasing non-residential rates.
Commissioners, do I hear a motion?
Madam Vice Chair, this is Commissioner Caston. I'd like to make a motion.
Commissioner Caston, please proceed.
Based on the information presented in Duke Energy Carolina LLC's application, the ORS report, and the company's response to the ORS report, I move that the Commission approve Rider 13 to the company's demand-side management and energy efficiency programs for the calendar year 2022 as filed by the company. This rider will result in an approximate rate decrease of $1.11 per month for the average residential customer using 1,000 kilowatts per month. The new non-residential rate with Rider 13 is higher than with Rider 12. However, due to the non-residential opt-out provision, the non-residential rider will apply only to those non-residential customers who have elected to participate in the vintage year 2022 programs. I also move that the company continue to monitor and seek program enhancements designed to improve the cost effectiveness of the non-residential Energy Wise for Business and the non-residential information technology energy efficient programs. With regard to concerns expressed by the interveners, I further move that the parties continue discussion of these matters in the collaborative. I so move.
Thank you, Commissioner Caston. Commissioners, you've heard Commissioner Caston's motion. Any questions or discussion? Hearing none, we'll proceed to a roll call vote. Commissioner Caston.
Aye.
Commissioner Irvin.
Aye.
Commissioner Thomas.
Aye.
Chairman Williams.
Aye.
Commissioner Powers.
Aye.
Commissioner C. Williams.
I vote aye.
And I vote aye as well. The motion carries.
Madam Chair and other members of the commission, item number 8 on the utilities agenda comes from docket number 2020-125E. Staff presents to the commission for consideration final disposition of Dominion Energy South Carolina Incorporated's application for adjustment of rates and charges.
Commissioners, you've heard the matter before us. Is there a motion?
Madam Vice Chair, this is Commissioner Caston. I'd like to make a motion.
Go ahead, Commissioner Caston.
On Monday, July 12th, the Commission resumed the hearing on the rate increase filed by Dominion Energy South Carolina after a 6-month regulatory pause agreed upon by the parties. The Commission was presented with a comprehensive settlement agreement supported by testimony, and entered into by all parties except CMC Steel, South Carolina, which does not object to the agreement. I move that the Commission approve the comprehensive settlement agreement. I believe that it is in the public interest for the Commission to approve the settlement agreement. Under the settlement agreement, a non-residential customer using 1,000 kilowatts per month would see a monthly increase of $1.81, which is a 1.46% increase from the current rate. As you may recall, Dominion sought a rate increase of approximately $9.68 per month in its application. This settlement significantly mitigates the impact of the company's rate application on all classes of Dominion customers, both residential and businesses. Also under the settlement agreement, Dominion cannot file for a general rate case before July 1st, 2023, with new rates not being effective prior to January 1, 2024, except where necessary due to unforeseen extraordinary economic or financial conditions, which may include, but not be limited to, changes in tax rates. This means, absent such unforeseen extraordinary conditions, the customers' rates will not be impacted by a general rate increase until at least January 1, 2024. There are other features in the settlement agreement which will be explained in the order. Before I can conclude my motion, I would like to thank all the customers, the people that took time to speak and participate in the public hearings. I also would like to thank all the parties who negotiated the settlement. This settlement provides finality to this docket so that the resources of the interveners, consumer advocate, ORS, and company can be used in other areas and prevents a protracted appeal and its expense. I so move.
Thank you, Commissioner Caston. Commissioners, you've heard Commissioner Caston's motion. Are there any questions or discussion?
Madam Vice Chair,
Commissioner Thomas.
I believe that Commissioner Caston misspoke. He said under the settlement agreement, a non-residential customer using 1,000 kilowatt hours. I believe he intended to say a residential customer, not non-residential customer.
Commissioner Caston?
That is correct.
Okay. So you accept that as a friendly amendment?
Yes, Madam
Clark.
Vice Chair, I do.
Clarification. Any other discussion or questions?
Madam Vice Chair,
Commissioner Carolee Williams.
thank you. I just want to add to what Commissioner Caston has said, and thank Dominion for agreeing to take this pause, because without the pause, this settlement would not have happened, and the collaborative work that went into the settlement could not have had the time to occur. Furthermore, I want to thank the citizens that participated in the public hearing. There were about 110 who called in over about 12 hours of hearing, and you were loud and clear in terms of the impact, and we appreciate that input as well. And finally, I just want to make a point about the role of stakeholders during this 6-month process. I believe that from the testimony we heard that it produced creative and meaningful results, and look forward to that kind of stakeholder engagement happening in the future. Thank you.
Thank you, Commissioner Williams. Commissioners, any further discussion?
Madam Vice Chair.
Vice Chair Belzer.
I heard Commissioner Thomas and then Chairman Williams. Commissioner Thomas.
Thank you. I would just like to make a comment in connection with taxes. So the amount of this rate increase is significantly lower than it would otherwise be due to federal corporate tax cuts. Corporate taxes were reduced in 2017. The 2017 federal tax cut created refunds that are being paid back to customers. Those tax bill related credits will end in 2025. It's important for customers to understand that this reduction in their bills is a refund of excessive taxes collected from ratepayers in prior years that will now be returned to customers as a result of the 2017 tax rate change and as a result of this settlement. I think it's important also that customers be made aware of the fact that if corporate taxes increase, customer bills may also increase. And that is a provision of this settlement. That's all I had. Thank you.
Thank you, Commissioner Thomas. Chairman Williams?
Thank you, Vice Chair Belzer. I will say that when the settlement was presented to the commission, I was very careful to read each term of the settlement and to make sure that I understood it and to ask some very difficult questions. I am not opposed to settlements. If the parties feel it's in the best interest of their clients to settle, then by all means settle the case. Regardless of how they feel about settling, I think it's important for the commission to make sure that we vet each and every term of the settlement. And I think we did that in this particular case. I note that all the parties came in on one accord and agreed that the terms of the settlement were in the best interest of the folks they represented. I would specifically note the consumer advocate, who represents, I would say, the average residential customer, the Office of Regulatory Staff that represents the using and consuming public, and even AARP that represents folks 50 and over that are members of their organization. All of those entities came into our hearing room and advocated for the settlement. And even still, I had questions because there were things in their individual form in the settlement that, if just assessed alone, may not be in the best interest. Maybe not, maybe so. But as a whole, I think the parties did a good job of getting to a result that is reasonable, that's just, and that's prudent. Again, that doesn't mean that some of the individual terms by themselves don't leave room for questions, like the $350 million in transmission lines or the 9.5 ROE. Who knows what would have happened at the end of the hearing if we would have actually heard the entire case. But again, when a settlement is reached, the commission welcomes to hear the parties as to why they believe the settlement is in the best interest of their clients. And I think the parties did a good job of making that case before the commission. So as I considered whether or not to support the settlement, looking at each individual term and then looking at the settlement together and then looking at the result, it's easy to see that this is in the best interest of, or the public interest. You just can't, we can't order the company to stay out for 2 years. The commission does not have the power to order the company to do that. We can't order the company to give up the $30 million to EE programs and to help customers in all classes with back due electric bills. We just can't order that. And so I think credit is due to all the parties to negotiate a settlement that reaches the result that we have here. And so, Commissioner Caston, I'm happy to support your motion. And I think that this is a new day in South Carolina. I think the parties here demonstrated a willingness to work together that I'm not sure that the commission has seen before. And so that hard work does not go unnoticed. And I'm excited for the future, South Carolina's energy future. Over.
Thank you, Mr. Chairman. Any further questions or comments? Hearing none, we will proceed to a vote, starting with Commissioner Caston.
Aye.
Commissioner Irvin.
Aye.
Commissioner Thomas.
Aye.
Chairman Williams.
I vote aye.
Commissioner Powers.
Aye.
Commissioner C. Williams,
I vote aye.
and I vote aye. The motion carries. Mr. Butler.
Yes, Madam Vice Chair and other members of the commission. Item 9 has to do with the 3 avoided cost dockets, 2021 88E, 89E, and 90E. And as I understand it, the commission wishes to skip this item at the present time for further consideration later, if that's appropriate.
That's appropriate. We have individual time scheduled to hear from these prospective consultants.
Okay, thank you, Madam Vice Chair. Moving on to item 10 then, docket 2013-92A. Staff is presenting for commission consideration an amendment to Commission Order Number 2014-766 regarding intervenor comment deadlines.
Commissioners, you've heard the item announced by Mr. Butler. Do I hear a motion?
Madam Vice Chair, this is Commissioner Caston. I'd like to make a motion.
Commissioner Caston, please go ahead.
I move that the comments date for interveners in Duke Energy Carolinas LLC, DSM/EE cost recovery proceedings, set in order number 2014-766, be modified effective in 2022 to July 1.
Commissioners, you've heard the motion of Commissioner Caston. Any questions or discussion? Hearing none, we'll proceed to a roll call vote. Commissioner Caston?
Aye.
Commissioner Irvin?
Aye.
Commissioner Thomas?
Aye.
Chairman Williams?
Aye.
Commissioner Powers?
I vote aye.
Commissioner C. Williams?
Aye.
And I vote aye as well. The motion carries. Mr. Butler.
Thank you, Madam Vice Chair. Moving on to our motor carrier agenda, item number 1 is the application of Nathan Barr Jr., DBA BC Enterprises, for a Class C taxi certificate.
Is there a motion?
Madam Vice Chair,
Commissioner Powers.
this is Commissioner
Commissioner
Thomas.
Thomas, I am looking right at you. I'm sorry.
It's quite all right. I move that the commission approve the application of Nathan Barr Jr., DBA BC Enterprises, for a Class C taxi certificate.
Commissioners, you've heard the motion of Commissioner Thomas. Any questions or discussion? Hearing none, we'll proceed to a roll call vote. Commissioner Thomas?
Aye.
Chairman Williams?
I vote aye.
Commissioner Powers?
Aye.
Commissioner C. Williams?
Aye.
Commissioner Caston?
Aye.
Commissioner Irvin?
Aye.
And I vote aye as well. The motion carries.
Madam Vice Chair, members of the commission, staff would recommend that items 2, 3, and 4 be considered together. We have requests for reinstatement by various carriers, and I'll go through those briefly. The first one is a request for reinstatement of Exquisite Ground Transportation, SC, for reinstatement of its Class C charter certificate number 9307A. Item number 3 is docket number 2020-141T, which is a request of Nathan Bryant, DBA Anointed Hands Global Transportation Service, for reinstatement of his Class C taxi certificate number 9522. And item number 4 is a request of Derek Campbell, DBA Darion's Transportation, for reinstatement of his Class C non-emergency certificate number 9482A.
Do I hear a motion?
Madam Chair,
Commissioner Powers?
I move the commission grant the request for reinstatement of certificates described by Mr. Butler in items 2 through 4, subject to all commission rules and regulations. I so move.
Thank you, Commissioner Powers. Commissioners, you've heard the motion. Any questions or discussion? Hearing none, we'll take a roll call vote. Commissioner Powers?
I vote aye.
Commissioner C. Williams?
Aye.
Commissioner Caston?
Aye.
Commissioner Irvin?
Aye.
Commissioner Thomas?
Aye.
Chairman Williams.
Aye.
And I vote aye. The motion passes.
Item number 5 is docket number 2021-131T, and there is a request of Northside NEMT LLC for an extension of time until August 27th, 2021 to comply with commission rules and regulations.
Is there a motion?
Madam Vice Chair.
Commissioner C. Williams.
Thank you. I move that the commission grant the request of Northside NEMT LLC for an extension of time until August 27th, 2021 to comply with commission rules and regulations.
Commissioners, are there any questions or any discussions related to the motion? Hearing none, we'll take a roll call vote. Commissioner C. Williams.
Aye.
Commissioner Caston.
Aye.
Commissioner Irvin.
Aye.
Commissioner Thomas.
Aye.
Chairman Williams.
Aye.
Commissioner Powers.
I vote aye.
And I vote aye as well.
Madam Vice Chair, that does complete the agendas before the commission with the exception of item number 9 on the utilities agenda. Thank you.
Thank you, Mr. Butler. We have a few minutes before 9:30. The commission will be in recess until 9:30. Thank you. We are back at the Public Service Commission with the continuation of our meeting, and we are scheduled at 9:30 to have interviews or talk to a prospective consultant. Ms. Boyd, do you have anything to add?
No, ma'am, I do not. Madam Vice Chair, I think our first interviewee is the entity Ascend Analytics LLC.
Okay. And let's take a roll call of commissioners first. See, virtually we have Commissioner Caston, Commissioner Irvin, Chairman Williams, are you on the line?
Yes, ma'am.
And we have Chairman Williams, present in the hearing room. We have Commissioners Thomas, Commissioner Powers, Commissioner C. Williams, and Vice Chair Belser. And let's see, who do we have as far, we've got Ascend Analytics, is that correct? Did I say that name correctly?
Madam Vice Chair, I think you have. Thank you. Live stream team, would you
There they
please-
are.
Okay, great. On the line, you should have Dr. Doris, Mr. Millar. I don't think he's participating though, but he is present. Dr. Mach and Mr. Mahawald.
Okay. Gentlemen, I think the way we will proceed is, if you'd like to do a introduction, maybe do a high level of your proposal and what you can do in response to the solicitation, and then the commissioners will probably follow up with questions if you would. And for purposes of our live stream and our record, we do have a court reporter present. Would you please state your name? I'm not showing your name showing up on the screen. So if you'll just, before you speak, tell us who you are, please.
Vice Chair Belzer?
Chairman Williams?
Before the bidder proceeds, I would like to raise a point of order. Do you think it's possible that after they make their brief introduction that they could answer the questions that they were presented with, and then if commissioners have questions after those questions are answered, they can ask?
Yes, Mr. Chairman. I believe
If there's no objection to that.
we can proceed in that manner. Gentlemen, did y'all hear the comment from Chairman Williams?
Yes, we did.
Okay.
And I think as part of our introduction, we'll actually be addressing the questions.
Thank you very much. You may proceed.
Okay. I'm Dr. Gary Doris, CEO of Ascend Analytics. I'm accompanied by Dr. Mock and Tom Hald and David Millar as well, who's not video present. Good morning, and thank you for giving us this opportunity to present in front of South Carolina Public Service Commission. I wanted to share my screen and just go over, get to the heart of this and some elements around avoided costs in our proposal that are unique in both experience and approach, and in doing so also address the question that was posed, which is how is Ascend Analytics as a software analytics and consulting company able to address avoided costs more effectively. Paraphrasing here. So with that, let me bring up a slide. And here we go. Can you see my screen at this point?
Yes, we can.
Excellent. So Ascend is, let's say, deeply versed in avoided cost proceedings, having testified about a dozen times. It's gotten to the point where Dr. Mock and Dr. Doris, me, really can't count. But we've done quite a few. It's about a dozen. In doing so, we've been involved in very intense and high stakes proceedings around avoided costs, where developers have a lot at stake, and so does the utility in maintaining the economics of their system. And in that regard, I think that's where we have advanced avoided costs consistent with both FERC's position and something that I think is at the essence of where we need to go today in terms of the economic calculations. It's important not just to read and follow, but it's important to understand the underlying economics around avoided costs. And it's the avoided cost to serve load, inclusive of ancillary services, which does include renewable integration costs, that needs to be determined. You can do other methods, and I put versus a generic unit calcs, which means avoided cost to serve load is the true marginal cost on an hourly time step for resources that are committed to serve South Carolina load. A generic unit calc would be just taking, what's the levelized cost of a new thermal plant, typically, a combustion turbine or a combined cycle unit. That's a very simple calculation, but it really doesn't get at the essence of the economics that the ratepayer faces in the value and or costs associated with new resources entering the system. In terms of proceedings and testimony, we're the only company that has done avoided cost to serve load under this marginal cost approach. So
Dr.
it
Doris?
is, yes.
Okay, this is Jocelyn Boyd at the PSC. May I ask two things of you, please?
Sure.
There is an image in the middle of your slide deck that says resize to change the video size or number of videos. Is there any way that you can remove that image?
I don't see that on my end. That's why I'm
I'm not seeing it here either.
Okay. All right. Well,
Would it be possible that you might be something that you could remove on your end then, since it's not on our end?
okay, it's gone now. I'm being told it's gone.
Thank you.
Okay, and the other thing I wanted to ask, I've been informed that your speaker volume is elevated. Is there any way that you can decrease your volume a little?
Yes, I think my wife asks that commonly of me.
Does that sound good? He's decreased his volume. Would you go just a little more, Dr. Doris, please?
A little lower? Okay, I'll just speak more softly.
No, don't speak it. We need to hear you.
Okay.
Yeah, that sounds great. And this is, I don't know if you introduced or provided the commissioners with your name, but you are Dr. Gary Doris, correct?
Right.
Okay,
I'm Dr. Gary Doris.
Thank you.
I believe I did that. Recognizing the time is of the essence, and there's a full day. I wanted to get to the heart of what we're doing and why you would want to work with Ascend. We're clearly highly credentialed, but that's not it. Inexperienced, but have, I think, to set the watermark for what is in today's world the appropriate economic lens to be looking at to determine avoided costs. And that's on a marginal cost basis, looking at each and every hour and determining what is the marginal cost to serve load. And we have significant experience doing this in regulatory proceedings, and we think this is important. When you start accounting for renewable resources, which are today the most common form of generation that we're looking at, is from an avoided cost perspective. we need to account for a broad range of weather, and that's something that we've done and advanced from simple deterministic weather normalized conditions. If a resource has a lot more variability inherent in its supply, there are dimensions that need to be accounted for in terms of costs, the integration costs for those movements up and down of thermal plants or other resources to integrate the renewable resource. There can be times where, because of minimum run requirements, thermal plants can't back down anymore, and there's actually renewable generation being provided in excess of load. A nice cool spring day and the sun's shining bright. That's something that needs to be accounted for because those megawatt hours would not be serving load. And it isn't, and generally the utility is not in the business of being a power marketer for the renewable developer. So we think we can account for these dimensions well in terms of a fair and balanced approach to determine avoided costs. Moving off of towards marginal cost versus an average cost approach that most systems take. It's really important to look at this systematically on an hourly time step. We also want to capture renewable integration costs. What are the incremental increases in ancillary services? Typically it's regulation and some incremental and decremental flexible generation called the Inc and DEC. We want to capture the renewable integration costs. And this is just part of what's being provided by the resource. If they can furnish their own flexibility, then there would be no integration costs. But we want to understand this dimension. There's more than just energy when you integrate a resource to the system. We want to capture the electric load carrying capabilities of resources. That's it's called the ELCC here, third to last bullet, on a marginal unit basis. So as we add more and more of this, let's say solar, the electric load carrying capability actually declines. So the first megawatt might be quite high, and by the time you've added 2,000 megawatts, the marginal contribution towards electric load carrying capabilities is different and less. So that's an important framework to have in place. And this is all about framework and setting up a framework to determine true avoided costs. And that's what we're trying to get at. And the idea is once you calculate avoided costs correctly, based on the marginal cost to serve load, this is determining the benefits and approach that keep both the ratepayer and the utility neutral. That's why it's worth going to the extra elements of looking at this on an hourly marginal cost basis. I think the approach that we have also is the only approach that provides the necessary transparency of the supply stack and the marginal cost calculations. So as we set up a framework, or if we were to undertake any of this analysis with our modeling constructs, we can create the transparency necessary to have trust in the avoided cost calculations and down to the hourly level for as long as you want. And that is, I think, really informative to make sure both the ratepayer and the utility are held neutral. That's all I had for opening statements on my end as to a sense avoided cost approach and our distinguishing elements. And I think in doing so, we are also addressing the question of, what does Ascend have to offer here?
Thank you, Dr. Doris. I believe that Commissioner Powers has some questions to ask.
Thank you, Vice Chair. Dr. Doris, good morning. We, of course, are interested in your work background and qualifications, and you've given us quite a good opening as to your procedure and how you intend to work in this matter. Have you ever appeared before the Public Service Commission of South Carolina as a consultant or representative for a party? And if so, which party, where, and what docket was that in?
No, I have not, nor have any of my colleagues appeared in before the South Carolina Commission.
Have you ever been retained as a consultant for Duke Energy Carolinas, Duke Energy Progress, or Dominion Energy, or any of their affiliates in South Carolina or other states? If so, when, where, and what were the terms and monetary amounts of the contracts?
I have not been retained as a consultant for South Carolina. One of the entities listed, Duke, is a software license customer of ours for, and they just license our software.
Commissioner Powers, if I may interrupt, Dr. Doris, would you stop sharing your screen, please, so that?
Oh yeah, thank you.
Thank you.
Appreciate that.
Sorry to interrupt, Commissioner. Please go ahead.
Thank you. This work you do with Duke, is that any sort of conflict with what we're asking in our dockets?
No, it's purchase of a standard product, and it's just a set license amount. So there's no advocacy of consulting activities directly on behalf of Duke, which is what the question was. There is a commercial dimension, I suppose, that they're buying equivalent of shrink wrap software from Ascend.
Have your employees, associates, contractors, or partners ever been retained to represent any investor-owned public utilities in South Carolina? If so, when and where, and what were the monetary amounts of those contracts?
No, we haven't.
Do you or members of your immediate family, partners, associates own stock in Duke Energy Carolinas, Duke Energy Progress, or Dominion Energy? If so, in whose name are certificates, titles, and what shares do you own?
No, we do not.
Do you have any reason to believe that you cannot serve as a fair, impartial, independent consultant for any of these dockets?
No, we do not. We think we can be fair and independent and have an approach that would yield a more true and fair calculation of avoided costs.
Other than the software contract, do you have any other ongoing business dealings with the parties in these dockets? If so, what would they be?
No, we do not.
All right. Are you currently in any negotiations to represent any of the parties before a Public Service Commission or Public Utilities Commission in this state or other states?
No, we are not.
Okay. Do you hold any licenses, degrees, designations, or credentials that qualify you as an expert in the field of electric utility matters?
Yes, I do. So does all the Ascend team. In that regard, I'm a doctorate in economics from Cornell University and undergrad in economics and mechanical engineering. And Dr. Mock is an undergraduate in mechanical engineering and holds a doctorate from Carnegie Mellon University in energy system economics.
Okay, and when were these credentials or degrees earned by you and by Dr. Mock?
My undergraduate degrees were bestowed in 1988 with distinction, and my doctorate was in, I think, 1996.
All right.
And friend, Dr. Mock?
Sure. My undergraduate was in 1996, and my doctorate was in 2012.
Thank you. Are you a member of any utility-related trade groups or organizations? If so, could you please tell us what they are?
I believe we are not. We're a member of, actually at the moment, we're not a member of any.
Can you provide a final written proof of any conflicts checked from your firm? We provide
Yes.
the name of all the parties.
Yeah, absolutely.
If you're hired as a consultant, are you willing to abstain from any unauthorized ex parte contact with the parties in these dockets?
Absolutely.
Are you aware of any reason that you or your firm should not serve as an independent expert in these dockets?
No, we are not. We believe that we can serve well as an independent expert.
If awarded a contract, what would be your schedule for project completion?
Dr. Mock?
Sure, we said 26 weeks as a timeline in the proposal. That is, that can be adjusted depending on the needs of the commission and the timeline for any of the hearings that might be associated with this docket.
Thank you. Are you able to estimate the hours per task or estimated total labor hours involved in these cases?
We provided that with the proposal. I have to pull it up quickly. I don't recall exactly what we put in there, but I can grab it. We estimated, like, once again, this is a high level, this is our assumptions based on the timelines, that it would be roughly 590 hours total. That's inclusive of any sort of hearing, testimony, analysis, and discovery requests, reviews, and preparation. So that's our estimate, is 590 hours.
Thank you. Relative to the requirements of Act 62, which we operate under here in South Carolina, and relative to avoided costs, what information does the commission need to receive from your firm?
I'm sorry, Commissioner, I don't think I understood that question.
Relative to the requirements of Act 62 and relative to avoided costs, what information would we need to receive from your firm? I think you gave a pretty good opening about it. Are you able to meet the requirements of Act 62? Are you familiar with Act 62?
I am familiar with Act 62, and it requires an independent review of avoided costs, and that we do the analysis. So I believe we would be able to provide a full, transparent, report on our analysis with all the data. We've done this many times for the commission in Montana, so I think we'd be able to satisfy all of the requests in South Carolina as well.
Thank you. Do you or your firm contribute to political action committees? If so, please identify what committees those are.
No, we do not in any form.
All right. Is anyone who currently works for your organization who worked for a public utility or solar company in the past?
No, nobody does at my company.
Is there anyone who worked for your organization in the past who currently works for a public utility or solar company?
No.
Is anyone associated with your organization who has any affiliation with any public utility or solar company?
Any affiliation with any public utility other than as customers and me as a ratepayer buying from a utility, no.
Have you ever drafted purchase power agreements? If so, when, where, or explain your experience in that area?
Drafting of purchase power agreements is typically reserved for attorneys. We've certainly reviewed them as part of project financing activities where we're brought in by banks to look at purchase power agreements.
Have you ever had to draft commitments to sell forms? If so, what capacity?
No.
If you would describe your experience with avoiding costs and avoiding cost methodologies, and if you would include specific information as to the time frame and for what purpose you've done so.
Well, the Center avoided costs nationally in terms of proceedings, and I'd say the spotlight across the nation just following this, it has been in Montana. And we've worked assiduously in this area to evolve the avoided cost methodology in Montana to be something consistent with the modern economics of power supply. And we've set the standard as to the most appropriate and balanced and fair approach for avoided cost calculations that would benefit jointly all parties because of its neutrality and finer granularity or higher definition economic lens to which avoided costs are rendered. In terms of approach, it's very simple. We look at the supply stack of the utility and what's the avoided cost on an hourly basis, the marginal unit to serve load each and every hour. And we're going to do this through time, looking at multiple meteorologies coming through the system, because that's what happens. There's a lot of variability in weather. We want to understand not this just on an average or what's called weather normalized conditions, but over real conditions and what this would look like, and what are the true values on a marginal cost basis with respect to serving load.
Do you have experience drafting data requests? If so, when, where, and what experience you have in that area?
We have significant experience drafting and responding to data requests. Yeah, and I'd say very steeped in this with respect to avoided cost proceedings in terms of the data requests, both requesting and responding.
Madam Chair, that would be all of my questions.
Thank you, Commissioner Powers. Commissioners, any other commissioners with questions? Any other commissioners?
Vice Chair Belzer,
Commissioner Carol Lee Williams.
thank you. Thank you for being here. Dr. Doris, I'd love to hear a little bit more about your thoughts on the differences between the Montana Public Service Commission processes and South Carolina's. Where are they? Where can we learn from them? Where are you able to bring expertise from them that's relevant? What's not relevant? How is wind, the experience with wind, which we don't have at this point? How are those kind of analyses relevant to the South Carolina experience? And I'll go ahead and ask you my other question, which is hourly data seems to be very important to your software, your analysis. Are you confident that that can be provided in South Carolina?
Okay. Dr. Mock, please feel free to support me with additional information here.
Of course.
So the first question, Commissioner, how is Montana and our experiences there relevant for South Carolina? And the answer is extremely. And we've done several proceedings, I'd say maybe 4 or 5, related to solar avoided costs in Montana. And some of them are solar plus storage. So it wasn't all wind, but either case, it's all about the economic lens that you're looking at and trying to set up a construct that is neutral for the ratepayers and the utility. It has to be the avoided cost to serve load. And the only way to do that is to run a high definition production cost model where we're stepping through time over a large range of meteorological regimes. By doing this, we're capturing the hourly benefits and or costs related to inclusion of, let's say, a solar farm in South Carolina. So we can understand the benefits of energy. We can also look at the integration costs. We can look at whether the resource is able to serve load or is creating surplus. And that's all part of our framework. Hourly is determined through production cost modeling. That's a common tool. It does need a little bit of advances, which are in place. It's all available commercial software in terms of calculating or having constraints around ancillary services, regulation, and ink and deck.
Sure, and I could just add a little bit to that, Gary, that the Montana work that we have done, like Gary mentioned, it captures the system-wide marginal cost to serve load, which is exactly what we would want to apply to South Carolina. And it's a model that we've developed, for Montana that's applicable anywhere. It also really matters your projection of the market prices. What is the trend going to be in 20 years, or 10 years in South Carolina's case, because we're estimating the value of this contract over the next 10, in Montana's case, 15 years. So that's important to get that part right, that market intelligence aspect. And we provide a neutral, non-biased projection of gas and power prices going out to the future. And then you mentioned hourly data is important, and that's right. We have found that wind developers quite often have that hourly measured data from on site where they use the Met towers. Solar providers typically do not. And we have a couple of publicly available resources. One is NREL, the National Renewable Energy Lab. They provide historical weather data where they can estimate what the solar generation would have been had a solar plant been built at a particular location. So we can get the latitude, longitude, go to these publicly available sites, and then get kind of a synthetic historical hourly data set that is correlated with the local weather data so that we can simulate that properly going into the future.
Thanks, Dr. Mock. I think with that, we've addressed your two questions.
Yes, thank you very much. I'm going to continue with some more questions that were provided in the list of questions that commissioners had. This would be under process and competency. The selected consultant will need to read and listen to testimony while doing their analysis. Please talk about your team's experience in similar situations with a compressed schedule and how you will undertake that work.
Dr. Mock, I testified maybe a year and a half ago. You've been doing right through COVID on this. You want to take the lead here, please?
Sure. So our team is well practiced, I should say, over the past 3 years, roughly. Most of our avoided cost testimony and dockets that we've participated in has been over the last 3 years. Myself and two analysts that work under me know the drill, I guess. They know what kind of analysis they need to do when I provide them with that directive. We know that there's a procedural schedule that comes out. What are the milestones? When are we likely to get requests and to be prepared for those requests? We have standard outputs that we have been preparing in advance when we go into these proceedings so that we're ready when they make a particular request. We can kind of have a good idea what they're going to be asking for, so we know we can be transparent and provide accurate information quickly. I think the process of paying attention to the regulatory schedule and the discovery requests there, and being able to prepare and provide input into that is something we are well versed at.
Thank you. This overlaps a little bit with that previous answer, but describe the approach and experience of your team's role to the commission regarding your team's ability to listen to testimony, absorbing new information and identifying any data, requests for additional information, provide testimony, addressing critical and relevant data to arrive at a fair avoided cost, and provide a clear written report regarding recommendations for fair avoided cost.
Well, we've provided, direct testimony, many pages of direct testimony from Dr. Doris and myself in avoided cost, and in Dr. Doris's case, other proceedings outside of the avoided costs realm. And so we've drafted the testimony. We've worked with legal staff, to review it. We have provided input on discovery questions for clients that we have represented in the past. And, we've provided analysis in response to intervener requests, so far as to providing, dashboard, we call it dashboard access into our models. If the commission goes in that direction, where we can provide interveners the ability to review our models through a read-only type of account. So we have experience writing the discovery questions, taking the testimony from other interveners into account when we're drafting our testimony, providing that transparent and in-depth view of our analysis to the commissions. And I think we're qualified to do all the things you just mentioned.
Thank you. How is your team equipped to undertake this work given the commission's schedule? What are the benefits of awarding, given the schedule of awarding? And I apologize, I can't remember if you're the one team that only applied for one. Okay, thank you. What are the benefits of awarding one contract to your team? Meaning, you would just be working associated with, I believe, the Dominion territory. I'll try to clarify that. Others are applying to work in all three jurisdictions, Dominion, Carolinas, and Duke Carolina and Duke Progress, as well as Dominion. And you all are applying just to work in the Dominion territory. What are the benefits of that?
I can take that on if you want, Gary. I would say the benefits are that we bring our in-depth experience from Montana to South Carolina. So I think we'd be able to provide a new viewpoint there and rigorous analysis that the commission would be able to take into consideration in their decision making. And in an abundance of caution, as Dr. Doris mentioned, Duke Energy does subscribe to our software. They license our software, but we don't consult them. But we decided that we would just apply for Dominion Energy just to make a clear distinction, there. But I believe that our previous experience, our analytical rigor, sets us apart from others, and that we would be able to provide a lot of useful analysis that would help South Carolina now and going forward in their avoided cost considerations.
There's certainly the benefit also of diversity of view, in the ability for us to reconcile and I'd say inform the other consultants. So you have our economic lens and experiences, which have, been quite refined over let's say the last half a dozen years in continuously being involved in this area, and I think leading the analysis of what is appropriate and what isn't in avoided cost, lessons learned. And you can get an additional perspective of another consultant, and we have the ability to bear resources and reconcile with them, and I think come up with something that is absolutely the best as a result.
Thank you. I'm going to ask this next question just to be thorough and see if there's anything you want to add to what you've already said. Describe your experience meeting the following elements of the scope: the response to discovery, being deposed, cross-examining, and testifying.
In the matter of, we obviously have done quite a bit in the public arena and regulatory commissions, be it planning activities or more specifically avoided costs here. And as mentioned at the outset, Dr. Mock and I have both testified about a dozen times combined, and are deeply steeped in the nuances and issues concerning economics of avoided cost calculations, and have experience formulating testimony, communicating ideas, and creating an understanding that's understood by all in words and terms that can be embraced and not overly complex. But getting at an economic calculation that does have some complexities.
Thank you. Our next questions, I think you've answered, but just to be thorough, do you have the ability to replicate modeling in-house? Will you provide that in-house, correct?
We have the ability to determine avoided cost calculations in-house. That is correct.
Okay.
And we have the approach that we've developed to create considerable transparency in the process of determining avoided cost calculations.
Do you imagine any need to outsource any element of that?
No.
Okay. What is again, you may have covered this. What is the experience of the person or the entity, the person who might be running the modeling, and does that person have any conflicts in these dockets?
Dr. Mock?
No, the team that's doing the modeling has no connection to any of our work in South Carolina with Duke.
Okay. I'm at the end of the list, and so some of these I'm trying to balance between whether to be thorough and ask them or just recognize that you've already answered them. So if another commissioner wants to jump in, because we're all looking at the same thing, feel free. But I feel like you've answered number 3 and 4, and now I'm skimming through 5, 6, and 7.
Let me go to Commissioner Irvin. Commissioner Irvin, would you like to go ahead?
Yes, thank you. In July of 2020, the Federal Energy Regulatory Commission, we often refer to as FERC, adopted major revisions to the regulations implementing avoided cost rates and an attempt to modernize the methodology. I wonder if you could give us a summary of your understanding of the changes and how they affect state regulatory authorities like the South Carolina Public Service Commission and giving us additional flexibility in determining avoided cost rates. Are you familiar with those changes that were made at the final rule in 2020?
Very much so. And we've testified under these conditions post FERC's ruling. And Dr. Mock, since you were the author of that testimony, I'll let you take the lead and then support.
Sure. So some of the proposed changes from then, the biggest one that I was aware of was the ability to use the location marginal price potentially in order to develop the PPA for the QF. That's probably wouldn't apply to South Carolina, I guess, if we don't have the locational marginal price down there. But there was a little more flexibility provided to the states, and they were trying to kind of rule on some of the details of in Montana. We've dealt with large wind developers building, for an example, a 320 megawatt wind farm, and then dividing it into 4 different QFs and saying, well, this is 4 80 megawatt facilities, not one 320 megawatt facility. And so I don't recall the wording, but I think FERC's ruling or guidance that came out then kind of clarified some of those types of details that, okay, yes, if you are 4 different facilities, then you have to be at least a mile apart. You can't be together in order, and then just kind of arbitrarily divide it up. Additionally, the question of batteries, to my knowledge, there has not been a QF that has included a storage component yet. And so I believe that FERC document provided some clarity on energy storage as being part of a QF. But I would have to review it. It's been a while since I've looked at it, to be frank, at this time. And I know that on the issue of batteries, that is a kind of a new thing that we've been developing in Montana that I believe will likely apply to South Carolina, if not now, very, very soon, because solar and storage is really growing in popularity. And so how do you handle the battery component of that when you're developing your avoided costs?
Thank you. And as I understand the final rule, they created new options for state regulatory authorities to determine the value of QF energy delivered as available. How would you define as available avoided energy rates?
As available is just the delivered energy at the marginal cost at that point in time. So there's 2 dimensions. One is as available, where there's no set schedule or pattern, typical renewable resource. And then there's flexible resources that have the ability to be dispatched. And so there's obviously different costs or value related to as available compared to dispatchable. And,
so does that mean that if it is dispatchable, for example, let's say a QF is operating a gas-fired facility, is that taken into consideration in adjusting their avoided cost rate?
Absolutely. There's multiple dimensions here, both the integration costs. The thermal plant that is dispatchable doesn't have any. Clearly, an app, let's say, weather is the fuel for most solar farms, and that's much more variable. So there's integration costs that has to be accounted for, both typically regulation as well as ink and deck costs. And there are sometimes, depending on how much of a resource is on the system, the energy might not be able to serve a load if there's excess. As I mentioned maybe earlier, on a mild spring day, with every resource at minimum load, it could be that it's not serving load. You just have excess. That's possible. So we want to look at this on an hourly marginal cost basis to understand the true value here.
So is it fair to say that a state regulatory agency has some flexibility in setting a higher avoided cost rate for a dispatchable resource as opposed to a renewable resource that's not dispatchable?
That is correct and appropriate with the underlying economics.
Thank you. No further questions.
Thank you, Commissioner Irvin. Commissioner Carolee Williams.
Thank you. I appreciate that pause. I have 3 questions left from our kind of standardized list. Does your team have the ability to review what the utility has done with respect to methodology and modeling and render an opinion as to whether that work was performed correctly.
We'd like to think so. We've been involved extensively in avoided cost proceedings and know the economic constructs and approaches and trade-offs between them. And we'd be in a very solid position to do so.
Thank you. Does your team have the ability to replicate the modeling performed by the utility to review for accuracy and correctness?
Absolutely. We're 65 people at Ascend, 15 PhDs, and avoided cost proceedings have been central to our business over the last half a decade, and we can model as well. And as you know, one of the entities, Duke, uses our software in some capacity.
Thank you. And finally, does your team have the ability to render an opinion as to whether the inputs used by the utility are appropriate or correct?
We'd like to think we're well versed in the inputs and what's required to determine an avoided cost calculation, and certainly could render an opinion.
Thank you. Madam Vice Chair, no further questions.
Thank you, Commissioner Williams. Commissioner Thomas, I see your light.
Thank you. Dr. Doris, just have one question, and this is relating to the conflicts of interest. Are you aware of the names of all of the parties to the Dominion proceeding?
I'm not aware of the name of all of the parties, but happy to listen and render an opinion if there's any conflicts.
Okay, so I mean, I can read those names off to you, or you can get back to us in writing after this interview. But we do need to have a final conflicts of interest check. And
right. Absolutely, and we've done one internally. I just personally wasn't involved, but we'll do that in writing following this engagement.
Okay, thank you.
Vice Chair Belson.
Commissioner Caston.
I think Dr. Mark is talking about speaking specifically on the hourly analysis. Is that correct?
Yes.
And as I understand it, if I understood it, I guess to get the most accurate avoided cost, you were saying that in essence, your firm would look at the service area of the utility and look at the climatological data. And then you would look at, I guess, the hourly, say, whether a storm in this particular area, clouds, whatever, and the effect it would have on whether that would be solar facility, or look at all those things in great detail rather than make assumptions in totality. Is that correct?
That is correct. Just to maybe clarify, we use hourly values for the past usually 3-5 years, somewhere in that time frame, depending on the availability of the data. And the goal is to have a simulation of the utility's territory where the customer load, the solar generation, the wind generation are all realistic and move together as they would historically. So what you want in your analysis is for those historical correlations or historical connections between customer load, solar generation, and wind generation. You want to maintain those in your future simulations and calculations of that service territory. So that's an important component that our software is able to maintain.
So if hourly data is not known across the system, but maybe in portions of the system, depending on, where the utility is relative to AMI or whatever, or the ability to gather that information. How would you handle that?
We've always found that utilities are able to provide historical data on the aggregate customer load, historical hourly data on aggregate wind or aggregate solar. I've never experienced a situation where the utility could not provide that. Having said that, we do subscribe to industry industry services. S&P Global is one example. We pay into the subscriptions where we can have access to pretty granular information across the world, I guess, but across the U.S. mainly is where we use it. So we have additional data sources in order to capture that. And I mentioned the National Renewable Energy Lab. We go to their website, to their database quite frequently if we want to model a future solar or a future wind site that it doesn't exist today, so there is no historical data to capture in order to model that. But a site like NREL would be able to provide us with the climatic data so that we could estimate the solar generation had it been built today or last year. So that hourly data, sometimes we struggle, but I've never been involved in a situation where we just couldn't get it. So if we have, we will be transparent. We will identify our sources, and we will be very honest about if we had to interpolate or do anything, any sort of cleaning to the data that in order to have a realistic simulation.
Okay.
I would further add, not delving into hourly would be problematic in terms of coming up with a true neutral calculation of what it costs. You would end up with something, honestly, that would be systematically biased and inconsistent with the costs of energy on an avoided cost basis. And it's the data is there today, and there's little excuse not to do that.
Thank you very much. And I guess to build on Commissioner Urban's questions, comments relative to avoided costs, so the greater detail and information you have, the greater, I guess, confidence you have in the ability to calculate what that cost would be. And for example, I think it stated, I think wisely so, that if it's dispatchable, if you have something that can be used instantaneously 24 hours a day or whatever, it has a different value to the utility than an intermittent source. Is that correct?
Yeah, very much so. And that's why it's essential to look at this on an hourly marginal cost basis, not only for the integration costs related to intermittent resources, but also for the likely conditions, maybe not now, but very near future, where there could be surpluses and the resource just isn't serving load. It's creating equivalent of dumped energy or curtailed energy that doesn't serve the ratepayer. Yes, it's being produced, but it can't be consumed. And it's not hard to look down the road and see that coming.
So rather than look across the system and calculate and avoidable cost rate, are you suggesting, or your company suggesting that you do that based on sources, based on value, or what?
Commissioner Caston, I think I understand where you're coming from. It's very appropriate to clarify. There's typically a small QF and a large QF avoided cost rate. The large QF, typically because of its size, would be done on a project-specific basis. And where you draw that threshold, whether it's 5 megawatts or 20 megawatts or something like that, moving into the large QF category. The small avoided costs, the small facility avoided costs, would be done on a quote unquote a typical solar farm, let's say, in South Carolina. And we would look at an increment of, let's say, 100 megawatts of those. That would be appropriate. Well, our job here is to set up foremostly an economic construct for both the small and the large QFs for rendering the costs, the avoided costs that benefit the ratepayer and keep the utility neutral. That's the idea. It's just to be the avoided cost. And averaging is a great way to obliterate the true economics because of the variability and time of day. The averages are going to be misguided and, as I said, inconsistent and biased with the true costs.
But you're not proposing that there would be different rates for different regions of the utility, but simply a rate based on those different avoided costs. Is that correct?
That's right. Based on the marginal contributions of a resource to avoid energy costs. And there could be site-specific dimensions with respect to that resource. Some might be in a cloudier area than another. But I think we could say for the small QFs, we can come up with something pretty normalized that makes sense. For the large QFs, it needs to be done following an established process that captures the hourly attributes in the project specifics given their size and relative import on the system.
Okay. And I appreciate your answering. I think it was Commissioner Carol Lee Williams' question relative to the Duke Energy Carolinas, Duke Energy Progress, why you did not solicit all three. Absent that particular issue, I assume you would have no problem doing that?
We don't have any problem doing that. And as you can tell, we did this with an abundance of caution, and we'd be honored to undertake that.
Okay. Thank you very much. I have no more questions, Madam Vice Chair.
Thank you, Commissioner Caston. Any other commissioners? I'd just like to follow up very quickly, if I could. Based on the work that you've been performing, can you give me an idea of the percentage that may have been done for investor-owned utilities versus consumer advocate groups versus state regulatory commissions versus solar entities or any other entities, environmental or developers?
Excuse me, can you clarify with respect to those parties you would like to
I'm just kind of I'm trying to ascertain y'all's experience kind of with a breakdown in those various groups. Have you done 10% for consumer advocates and maybe 20% for utilities or 15% for solar developers? I'm just trying to ascertain some of your experience across the spectrum of entities in this realm.
I've worked on all sides. We're neutral and independent in that regard. We have work ongoing today, and I'd say tangentially related to avoided costs and resource planning for the Arizona Corporation Commission. We also work on behalf of public power extensively. So maybe that's 10% for regulatory bodies. Maybe public power might be another 30%. Developers probably another, say IOUs maybe another 30%, another 25%, and the balance would be developers, I'd say.
Okay. So okay, that's helpful. Thank you.
I'd say pretty evenly split, with the exception of the smallest slice of between developers and utilities, with the exception, including public power is a separate slice of the pie. So roughly a third each, public, IOUs, and developers, and then a small slice, like 10% for the commission.
Okay.
The public.
When you say public, when you reference public IOUs, are you talking about municipal owned electrical, or just are those privately owned, investor owned utilities as well? I'm kind of confused with.
Sure. I think I'm sorry if I misspoke in that regard, Commissioner. What I was trying to communicate was public power, meaning co-ops, munis, power authorities.
Okay, but not necessarily privately owned utilities.
We do about an even split.
Okay.
A third, and a third for developers.
Very good. I just wanted to point out and follow up to Commissioner Thomas's question about any potential conflicts with the parties. I believe there is a requirement for a final conflicts letter that's due, I think, on this coming Friday. So we will ask the hearing officer to send all the bidders the list of parties in this docket, so you can ascertain that whether there are any conflicts with any of those parties.
Absolutely. We'll undertake that this week.
Okay. Thank you very much. Commissioners, any further questions for Ascend Analytics? Gentlemen, thank you so much. I recognize that it is very early where y'all are, and so I'd like to thank you for submitting this proposal and for your time this morning and being so open with this commission. Thank you very much for that. And I'm sure there'll at least be some follow up from the commission on regarding those conflicts checks. Thank you very much.
Thank you. Have a good day.
Thank you. Good day to y'all as well. We need to recess the this meeting for a few minutes to reset the stream and get everybody online again. So we will be in recess for 10 minutes. Okay. We're already running behind 10 minutes, and ask that our next presenter bear with us for just a moment, please. Thank you. Good morning and welcome back to the Public Service Commission. We are continuing with interviews of entities, persons that have responded to the Commission's RFP and the avoided cost dockets. First of all, let's do a roll call of commissioners. Appearing virtually, we have Commissioner Caston and Commissioner Irvin. Listening in telephonically is Chairman Williams. And appearing in or present in the hearing room are Commissioner Powers, Commissioner Thomas, Commissioner Carol Lee Williams, and Vice Chair Belser. And I believe we have Ben Johnson and Associates on the telephone or on the screen.
Yes, ma'am.
Good morning, Dr. Johnson. How are you today?
Good morning. I'm doing very well.
Okay. And are we ready to proceed with Dr. Johnson? Dr. Johnson, what we are asking for this morning, if you would give us an overview of your proposal. And I believe you were sent a list of kind of standard questions that the commission has of all of our, that we are going through with all of our prospective consultants here. And any of those that you want to touch on in your overview, if you could take maybe 5 or 10 minutes, just kind of in that overview, feel free to touch on any of those questions, and then we'll follow up with any that you miss and maybe some others, if that's acceptable to you.
Yes, that sounds great. I appreciate this opportunity to talk to you and to answer questions. And I appreciate the way you've structured this entire procurement process. It's very well laid out, and I've submitted, I hope, in paper or on PDF, as they say, answers to most of the things that you need as you go back through and study it. But I do appreciate this opportunity to try to highlight a few things and to answer any questions that you have. First, I should say we have a small firm. We have 2 consulting economists, and both of us specialize in the public utility industry. We've been both working for public service commissions and other government agencies that deal with the electric utility industry for many years. Let me speak first about Dr. Reading briefly, because no one in South Carolina would have met him, I think, but he was a professor teaching before he joined the staff of the Idaho Public Utilities Commission. By the time he left the commission and joined our firm in 1986, he was the head of their staff. His title was a Director of Public Policy and Administration. Now, Dr. Reading brought with him to my firm a strong background in economics, but he was also very helpful because he had a unique perspective that he had gained from working directly with the commissioners, seeing how they struggled to reach the correct decision in the cases before them, based on the record and the evidence that was in front of them, which was sometimes more limited than they might have preferred, as well as the broad perspective they gained in their prior positions, which they were sometimes legislators, they were attorneys, farmers, housewives, a variety of backgrounds that they brought, and it's a very interesting mix. But over the years, I learned a lot from him in understanding how to deal with the issues in front of us in a way that we can present them to a commission that help them do their job. And that proved to be very helpful. Over the years, we've been involved, and I lost count for the exact number, but I would estimate over 400 regulatory administrative proceedings, as well as some court cases in various states, and I think 1 federal case. Another thing to understand is we do have experience with reviewing avoided cost studies, the specific issues that you're dealing with in this procurement, but I think our experience in other areas is equally valuable. We've studied many depreciation studies over the years, embedded cost studies used in setting rate design, marginal cost studies, incremental cost studies, cost benefit studies, and a variety of different engineering studies used in making decisions internally within utilities, as well as during the review process. We've worked on cases involving electric, natural gas, water, sewer, and telecommunications utilities. Another thing to try to understand about our firm that makes us somewhat unique is that we have a very wide range of clients, but I also want to be clear that the majority of our work has been on behalf of large industrial customers in the Pacific Northwest, and government agencies that are directly involved with utility regulation, somewhat like the Office of Regulatory Staff here in South Carolina, as well as more specialized agencies that represent the interests of consumers, like the New York State Department of State Utility Intervention Unit, which is part of the New York State Department of State. They handle corporations, a wide variety of responsibilities in New York, but they have a specialized agency within it that specifically tries to represent the interests of residential, low income, and other consumers who are not ordinarily well represented in the proceedings there. So we, again, just using that one example, we have the range all the way from the very large industrial customers that we continue to work for many decades, as well as agencies that are specializing in serving a function before the Public Service Commission to bring evidence forth that shows a perspective of low income and residential customers. And with this background, I think we have a better understanding perhaps of the dilemma you're dealing with. You've got a kind of a difficult decision. It's a very interesting statutory provision, and it seems to be new, and I would assume you're still trying to figure out the best way to implement it. Now, you're going to face some difficult trade-offs throughout this process, but the fundamental one that I see is you have a choice between a firm that comes to these proceedings or this contract with either completely fresh eyes or very fresh eyes, but because they have very limited experience dealing with PURPA and the actual preparation and the nitty-gritty details of avoided cost studies. Or else you're going to be finding a firm that has more experience, but the more experience they have, the more you are running the risk that perhaps they're being inclined to look at some of the issues from the same perspective as the clients they've previously worked for. And that's your basic choice. You've got a lot of experience, but perhaps some incline to go certain ways on certain issues versus very fresh eyes, but maybe miss a lot of important issues or details, be much less efficient perhaps in studying what has been provided to them and helping the commissioners understand the actual nitty-gritty details of those studies that are generating the numbers that are being presented to you. The reason I think we're kind of uniquely helpful in that area is fundamentally because the nature of our client base over the years has been so diverse. I do not believe we've ever had a tendency to drift into the camp of one client or the other. I have learned how to navigate that pretty well. And basically clients understand up front that when you hire us, you're hiring a firm that has a lot of other experience, and we're not likely to simply present things from the perspective of the attorney who hired us or the clients who hired the attorney who hired us. Another thing to understand is we do have a lot of experience in PURPA. It stretches back 35 years. A lot of that experience was gained early on working for the public staff of the North Carolina Utilities Commission. We were deeply involved in how that state started to implement PURPA and dealt with various issues, including the decision to use the peaker method and the like. So it stretches back many, many years. And as a result, we've seen a lot of details that other consultants maybe wouldn't normally see because utilities tend to be very transparent and upfront when dealing with an agency like the public staff, and perhaps a bit more reluctant to share details or to meet in person, like with other types of entities that they might perceive as being contrary to their interests. So they tend to take a more litigious approach historically. Now, again, I'm just trying to give you some perspective, but the point being that we do have a lot of experience, including experience working in great detail with avoided cost studies. I think this diverse client base and experience gives us a high level of independence and objectivity, and I think we can bring to you what you want. To the extent what you want is some independence, but also a lot of technical expertise with actual hands-on experience, including experience in understanding how commissions have to deal with trade-offs and issues which are not fully developed in a record, and they need to stay within the confines of that evidentiary record while still trying to point towards better records in the future with more information. I think we're in a particularly good position to help you with that. You mentioned the opportunity to respond to some of the questions that were put forward by the parties. Let me first say that we did attach as an appendix to our proposal written responses to the questions that Duke Energy Progress and Duke Energy Carolinas suggested as potential questions. And I hope, and I would urge you to take the time to actually review those written responses. There were some similar questions that we just received from Dominion Energy South Carolina. And they asked for a few details that Duke Energy didn't. So let me try to mention that I'm more than happy to share those details if they're of concern to you. But more specifically, just to briefly say, I think you should know that we have worked in South Carolina in the past. The only time we've worked for a party to this proceeding was the time we worked for the Office of Regulatory Staff in docket number 2004-357-W/S. We've also been very upfront about the fact that we have done some work for solar companies in Carolinas, including some work that was in South Carolina. But that's not the only times we've been in South Carolina. Back in 1978, our firm worked on behalf of the Attorney General of South Carolina in a Carolina Power and Light case, which is a predecessor of Duke Energy Progress. That was docket number 77-354-E in 1978. And we also did a couple of cases on behalf of the South Carolina Long Distance Association. And that's another, I want to highlight that one because that's another good example of the breadth of our experience. We've done a lot of work at the time when commissions were struggling with how to allow some competition in the telephone field. We did a lot of work for commissions themselves, a little bit for consumer advocates during that time period, and we ended up getting some work from the long distance type companies. The only other thing I would mention is there was a question which was kind of interesting about whether we have any experience with something akin to this procurement. And well, there was a couple of things. I don't, any of these questions, if you'd like answers to, I'm more than happy to answer them, but I will mention one other thing just very briefly. We do have a little bit of experience, subtle differences between working for a commission and a commission staff. It came to light in an example. We worked in Alaska for a number of years, did maybe half a dozen or more cases over a period of time. We started out working for their staff. There came a time when they asked us to work directly for the commissioners because they felt like their evidence being brought forward was sufficient between the two major parties they had in front of them, which was basically a company called GCI and the incumbent carrier. And they wanted the in-house expertise and the ability to help work on setting a policy that went beyond the limitations of the evidence in the record. So they wanted help in basically figuring out how to get a better record, what issues to frame in the proceeding and the like. So we do have some experience directly like that. We've also had cases where it's kind of in a gray zone, where some states are actually quite free. If you're working for their staff, the staff talks directly to the commissioners, and thus the staff can get a sense from the commissioners of what kind of evidence they want in front of them. So we have a few cases like that out in Kansas, New Hampshire. Generally, I would not personally talk to any of the commissioners. I don't really have much experience with that. But what I'm trying to say is the people and the staff that I work for would often be the same people who are working with the commissioners on a day-to-day basis. And thus, I would have some insight into the kind of concerns they had, why they even brought in an outside consultant. And it was typically because they wanted a deeper, broader record than what the staff in-house could develop. They needed someone with deeper expertise to help fill out the record. So I'll try not to filibuster any longer, but that's my introduction. And again, any of these other questions, I'm more than happy to answer. And of course, I'm looking forward to the commissioner's questions.
Thank you, Dr. Johnson. Commissioners, Commissioner Powers.
Madam Chair. Thank you. Good morning, Dr. Johnson. We do have a series of questions, and thank you for your excellent introduction. Sounds like you're back in 77. I don't know about how that goes with fresh eyes, but certainly you have the experience, and we look forward to hearing more about it. I'd like to go through a few questions. Obviously, you say that you have worked in South Carolina, but my question is, have you ever appeared before this Public Service Commission of South Carolina as a consultant or representative for a party? I think you mentioned ORS. Any other parties that you've worked for or been involved in?
Yes, there were several cases. It depends on how you think of that question. Technically, I didn't work for any of the parties other than that one. But I want to be very clear, and some commissioners probably already realize this, that I did some cases a few years back in which I worked for what's in a sense a predecessor of one of the parties currently in this proceeding, which was called the South Carolina Solar Business Alliance, I think. And so I did, I think it might have been 3 cases. One of them I think might have been settled involving a Duke, as I vaguely recall, and also a couple of other ones involving South Carolina Electric and Gas, where my client was the Solar Alliance, and the bills were essentially being paid by some of the large solar companies in South Carolina.
Have you ever been employed or retained as a consultant for Duke Energy Carolinas, Duke Energy Progress, or Dominion Energy, or any of their affiliates? If so, when, where, and what are the terms and amounts of those contracts?
No, I have not.
Okay. Have you or any employees, associates, contractors, partners been retained to represent investor-owned public utilities in South Carolina? If so, when, where, and what monetary amounts of those contracts?
No.
All right. Do you or any members of your immediate family, your partners, associates own stock in Duke Energy Carolinas, Duke Energy Progress, or Dominion Energy?
No, and of course also not for their parent company either, so no.
All right, thank you. Do you have any reason to believe you can't serve as a fair, impartial, or independent consultant for any of these dockets?
No.
Do you have any ongoing business deals with the parties in these dockets, and if so, what are they?
No, and that includes, just to be clear, any of the, as far as I know, any of the member companies of the association that's representing the solar industry in this proceeding. I have nothing going on currently with them. It's been quite a while since I worked with them.
Are you currently in any negotiations to represent any of the parties before a Public Service Commission or Public Utilities Commission? And if so, what are they?
No.
Do you hold any licenses, degrees, designations, credentials that qualify you as an expert in the field of electric utility matters? And what are those credentials, and when did you earn them?
Yes, I graduated with honors from the University of South Florida with a Bachelor of Arts degree in economics in March 1974. I earned a Master of Science degree in economics at Florida State University in Tallahassee in September 1977. The title of my master's thesis is A Critique of Economic Theory as Applied to the Regulated Firm. I graduated from Florida State University in April 1982 with a PhD degree in economics. The title of my doctoral dissertation is Executive Compensation, Size, Profit, and Cost in the Electric Utility Industry. I have more than 40 years of personal experience analyzing rate filings, cost studies, and other information concerning electric utilities, as well as other types of utilities.
Thank you. Are you a member of any utility-related trade groups or organizations, societies?
No.
And there's a list, and part of this procedure is going to require a conflicts check, and there's a date for that, which will be given to you. Can you provide a final written proof of conflicts check from your firm as to any parties in these dockets?
Yes.
If you're hired as a consultant, are you willing to abstain from any unauthorized ex parte contact with the parties in these dockets?
Certainly.
Are you aware of any reason that you or your firm should not serve as independent experts in these dockets?
No, I'm not.
What would be your schedule for project completion?
Well, I haven't come across any statutory deadlines. There may exist, but I'm sorry, I don't know what they are if they do. And nor have I seen any clear indication the Commission has established a specific timeline for this phase of the proceeding. I have seen some indications of the pace that it's going at currently based on the activity so far in at least one of the dockets that I looked at. I did find that in an earlier docket in 2019, I think it's 2019-186-E, that your consultant was hired in early September 2019, and then various steps happened leading up to a decision in about November 15. So from my perspective, that's a pretty expedited time frame. or a compressed schedule compared to some other state proceedings over the years I've been involved with, which would typically stretch out over a longer period. So from my perspective, more time is better. More opportunities for the parties to present information and to challenge the evidence is always better. But of course, I do understand that sometimes there is a pressure on the commission to process a filing quickly to move on to other business. So to be clear, I'm more than willing to work with whatever timeline you have. I think anything less than that roughly 10 or 12-week time frame, it would be very, very difficult to deal with, particularly to give an opportunity for the parties to review the report, ask discovery and depose the consultant, and to cross-examine the consultant, which I think are steps that are appropriate and helpful. So ideally, you'd have more time than that 10 to 12 weeks. But just to be clear, I don't have any firm commitment to a specific time frame. In general, I would lean towards giving yourselves more time to develop a record and make a decision to the extent you can, but I'm willing to work within whatever guidelines or constraints may exist.
Okay, you feel you could work within a reasonable time frame?
Oh, absolutely.
Are you familiar with the requirements, or are you familiar with Act 62?
Yes.
Relative to the requirements of Act 62 and relative to avoided costs in particular, what information does the commission need to receive from your firm?
I think you've already obtained everything you need. Certainly if you want to ask for more details, more specific docket numbers, I try to sprinkle a few in here so I'm not seeming like I'm hiding the ball. But if there's something else, additional detail, after you folks review the written materials and want to come back to us, more than happy to provide anything extra you might need or want to receive.
Thank you. Do you or your firm contribute to any political action committees, candidates, or any political parties?
No.
Is there anyone who currently works for your organization who worked for a public utility or solar company in the past?
Not as an employee, but as I mentioned, our firm has provided some consulting services to solar companies and or groups of solar companies that appear before commissions, including this commission. It's been more than a year. I think it's probably 2 years or roughly since we've done anything like that, but we have done that in the past.
Is there anyone that works for your organization in the past who currently works for a public utility or solar company?
Not to my knowledge. We've had a lot of employees over the course of 40 years, and some of them ended up at commissions, and it's conceivable one of them ended up from there in the utility, but I'm not aware of any, not in contact with them if they are.
Nothing that you feel would be a conflict?
Oh, no, not at all.
Is anyone associated with your organization who has any affiliation with a public utility or solar company?
No.
Okay. Have you ever drafted purchase power agreements? If so, when, where, and what experience you have as far as energy source involved?
No. I've seen some of them, but I've never drafted any.
Explain how wind-focused avoided costs or other energy sources not commonly found in South Carolina may be relevant in South Carolina.
Well, many of the same issues apply, and the study methodologies are often similar. But there's some important technical differences, and succinctly, the main difference is the timing of energy. Wind tends to be produced at night when it's not as valuable in most places, and it's, of course, varying with wind conditions. So if you're in an area that has steady winds constantly, that's not a concern. But as you move out to other places, whether or not you'll get enough wind over the course of the year to make a cost-effective investment becomes a concern. Be a little bit analogous to, say, in the case of solar, if you go to Canada, it's not as easy to make the numbers work as it is in South Carolina. Again, the difference is basically there are technical differences, but it's mostly a question of the timing and the need to study hourly and seasonal production and demand patterns, which again are analogous, but there's some important differences.
Have you ever drafted commitment to sell forms or been involved with any experience with that?
No, I've not drafted anything like that.
Please describe your experience with avoided costs and avoided cost methodologies, and if you would, include specific information such as a time frame and what purpose, including the state where this occurred, in your opinion, as to the relevance to South Carolina.
Yes, we've been working on PERPA and avoided cost issues since 1986. At the beginning, we worked for the North Carolina Utilities Commission public staff and did a series of cases for them. And then they, at one point, referred us to a qualified facility in the state that they had a dispute with this qualified facility over the rates. And they recommended to that company that they hire someone with local expertise, and they waived any potential conflict and said we just will have the better data and better information in this proceeding because it's an arbitration, and they were concerned the commission was going to struggle. So anyway, we worked on that case. I think I can't remember Epcor. I can't remember the exact name of the company. It was a Canadian company that was investing in North Carolina. So we did some work for them, which dragged on for well over a year and got very, very detailed. They ended up hiring Ventix, which is a production cost modeling software company that Duke Energy Progress at the time. I think they were Carolina Power and Light. I can't remember where that was in all that time frame. But anyway, we worked on that case, and that gave me some real insight into the production cost modeling process because they had brought in a specialist from Ventix. This Canadian firm used Ventix as well, and for other regular stuff, they do hydro and other things up north. Anyway, so we got a lot of experience there in that particular arbitration proceeding. I think it was ultimately settled, but it took a while. And then we continued to work for the North Carolina public staff in that state on other matters, rate cases and the like through that time frame. Then we briefly did some work, briefly relative to my 40 years career. I don't remember, it was 5 years, whatever. We've done a series of cases in North Carolina off and on for a couple different clients, but they basically were concerned about sustainable energy and the like. And as far as I can tell, the funding was coming from the primarily, but not entirely, I suppose, coming from the qualified facilities in that state. And so they knew I had the in-house expertise and specific knowledge of North Carolina and asked me to work with them, which I did. And that's all public record. And those cases and the testimony I filed is all a matter of record. The most recent proceeding that I can recall was about 2 years ago. And I know for sure nothing in the last year for any of those clients in North Carolina or South Carolina or any on solar issues or presentations to either commission.
Do you have any experience drafting data requests or working through discovery, preparing discovery?
Yes, very extensive. And I've seen it from the perspective of like a state commission staff, which tends to get a lot of cooperation. And I've seen it from the perspective of where you're in a court litigation and it's, the attorneys are very, very meticulous about only answering what is specifically required to comply with the rules. So I have a lot of experience in that and knowing how to draft requests as well, informal requests, as well as formal interrogatories, requests for admissions, requests for production of documents. Again, it really just varies with the forum, but the basic art is the same, which is you really have to study the details of what you have in front of you so that you can formulate the questions very precisely to make sure you get what you need. And I've never had a problem with companies giving us back what we need if we're precise enough in what we ask for, unless they object. And of course, that's their right. And that's often part of the process, particularly in the litigated court cases.
Given the schedule and what you understand now about this work, describe the work you would propose to do, what team members you would be responsible for this work, and specific competencies to do this work.
Well, I would propose that I do the bulk of the work since I'm already here down in the Southeast and I have so much familiarity with these utilities and the way they do their studies. But I would like to bring Dr. Reading in as well, both because of the compressed time frame, because he brings a really valuable perspective. He's seen how these types of studies have been handled in the Pacific Northwest. And he brings in additional perspective. I think it would be helpful. I also think you should seriously consider hiring more than one firm. You do have a variety of consultants in front of you, and you've got 3 different proceedings. And from what I've read, you seem to have some flexibility to structure the contracts however you want to do. So if there's some gaps in our background, or you're feeling like one of the other consultants has some expertise that would be particularly helpful. I see no problem with having, say, 2 or 3 firms brought on board and allowing them to collaborate. I don't know the details of how you can structure that, but I've not seen anything in the statute that would preclude you from doing that. But again, if you want to just use one firm, I think we're probably as good a choice as you're going to have in front of you, given our expertise and the tight timeframes. There's not a lot of opportunity for moving down a learning curve. Anybody, the newer they are, the more you're going to have a difficulty with, did they really bring a lot more data and information in front of you that wasn't already there from the parties?
The selected consultant will need to read, listen to testimony while doing their analysis. Tell us about your team's experience in similar situations with a compressed schedule and how you would undertake both these tasks and do this work.
Yeah, again, if we worked in 400 proceedings over 40 years, you can imagine I've obviously been asked to look at transcripts many times. There have been times when I've asked to sit and watch live testimony, either in the back of the room or at the table up front, adjacent to my client. So I have experience with all of that, and I've kind of learned over the years, if you're trying to save money, if you're doing it quickly, reviewing a transcript tends to be less cost effective, more cost effective, less time consuming, because you can read faster than you can listen. And coffee breaks, you don't have to sit there and pay someone to sit there. But as far as, understanding what's being said and being able to drill down and understand the key passages and where the really important back and forth is, and where a witness has struggled to remember the details of, to be gracious, of what they did, or perhaps is not trying to avoid volunteering too much because they've been guided towards staying away from some areas. I think I have a good sense of that, and it's just part of the process. It's both sides do it, and the attorneys are always attempting to shape the record to present the message that they want to emphasize. So I have a lot of experience with that, again, over 40 years, 400 proceedings.
It pretty much covers my next question, was as to the ability to listen to testimony, absorb new information, identify any data requests while in the middle of a procedure. You're capable of doing that?
Absolutely. And I want to reemphasize something that I drew attention to earlier from my experience in Kansas and New Hampshire and Alaska and other places, where the main concern of my client was making sure the commission had a good record. They didn't necessarily feel that strongly about what rate of return should be adopted, but they put on a witness. They didn't necessarily concern that much about, the details of every issue. What their number one commitment was to make sure the commission had a full record and fill in the gaps. And that gave me a whole different perspective that I've kept with me throughout my career. Ultimately, a concept that was explained to me once by an attorney in a court case, because they said, look, you folks that do these administrative proceedings, things get a little sloppy sometimes. Be very, very careful. You never, you're hired to bring in an opinion. Never have an opinion on the ultimate question. That's a no-no in court. And I said, oh, interesting. But I had been doing that in a way for many years because of the work for commissions. So I might over time come to a pretty strong sense that on a particular issue and a particular set of facts, the requested rate of return was higher than it should be. And I might have had a sense that the number being presented by another witness for another party had gotten off on the low end of what I thought was a reasonable range. And my own opinion might have been somewhere in between, almost always was. But my point I'm trying to make was I always try to present it in a way where I was not in any way painting the commission into a corner. It was their job to weigh that evidence, their job to take the heat if the rate increase was greater than what the public really wanted. So what I'm trying to say is I believe I have a lot of experience in trying to provide evidence, fill out a record, help interpret a record, and explain the nuances of what's going on without putting the commission in a position where they're attempting to rely on their expert's opinion. It's a matter of having enough information so that the commission can make that decision. And that's a concept that I've dealt with for many, many years, and I think it's served me well. It's allowed me to present concepts that get shot down, commissions reject it, and they come back and hire me again the next time because that was the commission's decision. And And I don't have any problem with that. That they're the ones paid to make that final decision on that ultimate question, not me.
You think in providing testimony, you'll be able to address critical and relevant data to arrive at a fair avoided cost?
Absolutely.
Are you able to provide a clear written report regarding your recommendations for fair avoided costs, which could be easily understood by commissioners and staff?
Yes, I think we can. And again, that's one of the skills we've developed over the years. Of course, I may think something's perfectly clear. And if someone has never dealt with the industry before they got this job and they've only been on the job for a year or so, it can still be a real challenge. There's so much jargon and so many concepts, but I think we've learned over the years how to write a very clear report, define terms, and provide that roadmap you need to work your way through the maze of conflicting back and forth opinions that you're presented with.
How's your team equipped to undertake this work given the schedule? What are the benefits of awarding all contracts to your firm? I mean, this is a lot of work.
It is. And the main benefit is you might save money. Basically, there's going to be some economies of scope. This is most obvious in the case of Duke Energy Carolinas and Duke Energy Progress. I haven't looked at the filings, but in my past experience, they typically file very similar data in the parallel proceedings at the same time frame, with some important differences based on their characteristics of their load and the specific details of their particular tariff. But there's a lot of similarities. So if you get the same firm dealing with Duke Energy Carolina in Progress, you're going to save some money. Not so much, but still some savings if you use the same firm on Dominion. But I have no idea what they filed in this case, I'm sorry. But I do know from the past, from working with Dominion Energy's North Carolina utility, that they have a whole different set of people and different approaches that they were using. And of course, the South Carolina Energy, Electric and Gas, also has its own methodology. I'm familiar with what those all were as of a few years ago, but these methodologies keep evolving. Every time I've ever been brought in, there's always changes. Generally, the trend is towards improving accuracy, adding detail, clarifying issues that have become controversial in the past. So you're going to save some money, but frankly, if you're going to use a single firm on all three contracts, I would recommend you do that if you can stretch out the schedule a bit. It can be very hard to get all of the benefit of what you're seeking for in this legislation, what I think is trying to accomplish through this legislation. If you also try to do it in a 6 or 8 week time frame, from the time the consultant's fully on board and able to be paid to the time they're expected to put together a draft report, that's going to be tough. If you can figure out a way to have a collaboration of a couple of firms, they could be working in parallel on different cases, maybe one on Duke Energy Carolina, one on Progress, and are allowed to talk to each other. That would be a little more costly, but you might get a better product at the end of the day because you've got more minds working on the problem. Everybody's going to bring in a little different perspective. If you are wanting those fresh eyes, obviously we're not going to give you purely fresh eyes. I can't claim we are. We just aren't. On the other hand, I think we have an objectivity and an independence that is what's needed and what's sought in the statute. So even if you choose just to use us, I think you'll be fine. But if you want those fresh eyes and can figure out a way to run them in parallel and allow them to talk to each other, that might be a good solution. It's not as important with Dominion because they tend to use different modeling, but there's a lot of similarities. I mean, obviously, let's talk for a moment about production cost modeling. The production cost modeling in part ties into the generators surrounding them and the demand characteristics of the load in that surrounding area. And there's interchanges constantly happening, minute by minute to some degree, certainly hour by hour. So there are some overlaps, and having either the same firm or a small group of firms collaborating together, talking to each other and working on the Dominion problem at the same time they're working on the two Duke cases, you would end up with a more comprehensive report with greater opportunity that maybe one of the consultants working on, say, Dominion notices something, an assumption that might be perfectly valid. And if it is valid, perhaps should have been applied in the Duke case or vice versa. And to bring that forward to the commission so they become aware there's a little, maybe not critical, but important inconsistency in the assumptions being made in the Dominion proceeding and in the two Duke proceedings. If you had that opportunity to allow that the same eyes, whether it's a single firm or a group of firms, looking at all three at the same time, there'd be some benefit to it. But again, there is a cost trade-off. The more firms you bring in, the more it will ultimately cost you.
Dr. Johnson, you've answered my next question, which was what would be the benefits of awarding only one contract to your firm? So I'll move
Yes,
on.
I saw these questions in advance. I guess I had it on my mind.
Okay. Describe your experience meeting the following elements of the scope of respond to discovery, being deposed, cross-examined, and testifying.
Again, I'll try not to be redundant, but again, we 400 proceedings, 300 of those, I think over the years, I actually testified many times, not anywhere near as many, but I have been deposed dozens of times, mostly in court proceedings or like tax proceedings, other types of proceedings where depositions are common. So I have experience with being deposed as well as helping attorneys formulate questions for a deposition. And of course, a lot of experience being cross-examined.
Do you, as a prospective consultant, have the ability to replicate the modeling in-house? Or would the modeling have to be outsourced to another entity?
I guess it depends a little bit on how you think of the word modeling. So in these proceedings that are in avoided cost studies, there are aspects of it that we have in-house capabilities, have our own approach, which we use when we don't have access to the work papers or the details of a utilities avoided cost study. We've developed the ability to basically get very, very similar, if not identical results using our own model for some parts of it. On the other hand, for the hour-by-hour pattern of energy costs, what's typically used is a production cost model. Those models are most typically used by utilities to determine, to predict basically on an hour-by-hour basis what their cost structure will look like and what the neighboring utilities will look like. So they do a lot of modeling. They have in-house expertise. They have people who are dedicated to that job, and they license software that's very powerful, but it's also very costly. And no one else really has, until maybe recently a little bit, because some of the environmental groups have gotten involved and trying to deal with, suggesting that we have less coal or whatever. So there's become a market in recent years, perhaps, and for production cost modeling, but not until very recently. Historically, it's strictly in the utilities wheelhouse. And so the only consultants, the only folks who really had that expertise are either working directly in a utility or work for utilities. I have some experience with working with those kinds of experts where our client, hired and brought in one of those consultants, wasn't concerned necessarily about conflicts. The consultant didn't have any direct conflict with that particular utility at that particular time. So I do have some perspective that most people in my position would not have on the production cost modeling process, but I certainly don't have the ability to do it myself. Instead, what I have is the ability to ask questions and have the utility modify their runs to change assumptions or change inputs or to structure it based on a different configuration. If you, for example, were interested in what would happen if you had fewer coal plants and you did or did not bring in more natural gas plants to replace them, scenarios like that might be of real interest to the commission. I think I have the ability to figure out how to explain what we want done and ensure that it's done correctly.
If you used another entity to do the modeling, would that entity have any conflicts in these dockets? And could you assure us of that if you did?
I don't have a specific entity in mind. The ones that I've worked with in the past will have, to a degree, conflicts. It's just the nature of it. It's a firm I've worked with that works in the Southeast, and they don't think I'm talking, I'm sure this is public knowledge. So this particular firm works for Santee Cooper. They're excellent, and if you're willing to waive the conflicts, and if they were willing to work for you, which I can't say they would, because they probably have connections to Dominion, and it might be uncomfortable for them. So, there's firms like that out there, but again, this area of production cost modeling is a little tricky. Pretty much everybody's either going to be working with environmental groups or they're working for the utilities, and most of them work for the utilities. I don't know there's a simple solution to it. This firm Ventix I mentioned that produces the software that Duke relies on, I'm sure if the commission asked Duke to waive the conflict, Duke might be willing to do that. I don't think there's any reason why they shouldn't be willing to, but I'm not trying to put words in their mouth or put them in a corner at all. I'm just trying to say there might be a solution to it, but it's a tricky problem. The easy solution is one I've done historically, which is just hire the right consultant. I think we could do it, that knows how to ask the questions and knows how to work with the utilities' own software, their own experts, the ones who do it day in and day out, and get the runs you need for the scenarios you're interested in. So basically being a go-between between the commission and those in-house experts in some manner. And I realize you have all these ex parte rules and things we have to be very careful, but I'm sure there's a way with ex parte briefings or other processes that are totally transparent, totally public. If the commission wants to see a run that matches a certain scenario that they've been thinking about, there's no reason you can't get to that point in a perfectly appropriate manner with plenty of opportunity for the utilities and the other parties to weigh in and explain why they disagree with those assumptions or why they don't think that's as useful or as reliable as the ones that they provided to you.
So as a consultant, you feel capable to have the utility rerun modeling with your inputs and ensure that the modeling was done correctly?
Yes, absolutely. We've done that for years, and I'm very comfortable that we have the skills we need and the ability to do it. And again, I've always had a lot of cooperation with utilities. Sometimes there's instances in which there's objections. For example, a classic objection would be you're asking for us to produce work for you, and we have no obligation to do that. They may waive it as part of settlement discussions and the like. But in your case with this statute, you clearly have the ability to obtain that because you can waive the only objection in essence is you're asking the utility to spend some money because people have to be working on this instead of something else. And that's just, that's a burden arguably in civil litigation, asking the plaintiffs, if you're the defendant, asking the plaintiff's expert to do runs is something you can only get done unless you get the judge to agree that that's an appropriate request. And here, this case, the intent of this statute, I just can't imagine any of these utilities, once, depending on how it was formulated and the way it was presented, and it was clearly it was commission was interested in it and wanted the work done, I don't see there'll be any problem. And then once there wasn't a problem with that legal issue of spending money, I don't think there'll be any problem whatsoever with ensuring that the runs we get back are correctly formed and match the specifications we gave them. There's no question in my mind they'll do an honest job of doing what we ask if we're specific enough about the inputs.
Do you feel as a consultant then that you'd have the ability to review what the utility has done with respect to their methodology and modeling and render an opinion if their work was done correctly?
Yes.
Do you feel you have the ability to replicate the modeling performed by the utility to review for accuracy and correctness?
Yes, with the caveat I already mentioned, which is on the production cost modeling. I think I have the ability to find if there's errors or inconsistencies, but I wouldn't be able to fully replicate it.
Okay. Do you feel you have the ability to render an opinion as to whether the inputs used by the utility are appropriate and correct?
Yes, but I do want to caution you, many of these inputs, there's not a right answer. It's a matter of opinion. So for example, just use a simple example, what inflation rate is going to apply over the next few years is going to be a big issue because we've had a long period where the Fed made it very clear it's 2%. Now we're in a time period where there's some uncertainty. And so there isn't a right answer. If one of the utilities, say Dominion has bumped up their inflation rate a little bit and Duke hasn't, or vice versa, I have no idea. There isn't a right answer or wrong answer. It's just one of those tough details that you have to pick a number to run. So with that caveat, I don't have any question that I can render an opinion that will be helpful to you that is just is independent and is not simply based on accepting what one party or the other is advocating.
Dr. Johnson, we're going to provide you with a list of all parties involved in this, and we're expecting a letter, a conflicts check letter, by no later than the close of business on Friday, July 23rd. Are you able to meet that deadline by looking at this list that provided today?
Yes, if it's possible to get the names of the people behind the parties, if that's what your concern is, it would be helpful. Otherwise, I can do the best I can to respond. Certainly I can respond based on the name of the party. The question, let's say the environmental group, it's very unlikely that we've done any work for anybody funding one of the environmental participants, but I have no idea who funds them. And so depending on how you word the question, please be careful that you don't ask me to certify to something I can't know, because I have no idea who's funding the environmental groups, for example. But I've never worked with any environmental groups that I can recall, and certainly not in the last 10 years, and none of the ones in the Southeast. So using that as my example, I don't think there should be any kind of a problem giving you the certification you need.
Dr. Johnson, thank you for being so responsive. And Madam Chair, that'd be all the questions I'd have at this time.
Thank you, Commissioner Powers. Other commissioners with questions?
Madam Vice Chair.
Commissioner Caston?
Still morning. Good morning, Dr. Johnson.
Morning.
Relative to, and I wasn't sure if I heard the answer or not, but relative to an anticipated number of man hours, say for all of the utilities for performing this work on all three of the utilities, do you have an idea of what that estimated man hours would be?
I can give you some insight into it, but it's a difficult question because first, we don't have a firm schedule. At least I haven't seen a firm schedule. And from experience, I know that when I've worked for clients that said, well, this is our schedule and, it's going to be a crunch and we're going to have to do everything in a certain number of weeks, then I gave them an estimate and I did very successfully at staying within that estimate, making sure they weren't happy, except towards the end, all of a sudden there was a 2-month extension because something was blowing up. And then all of a sudden more questions happened and more work was needed and there was additional filing. So my point being, any kind of an estimate I give you is dependent in part on the timeline, the schedule. I would say if we were working on just a single proceeding and other consultants were handling the other two, a reasonable estimate, assuming similar time frame to last year, but stretched out a little longer to provide an opportunity for depositions of the expert, cross-examination of the experts, which you clearly are now anticipating. Given that kind of a time frame, I think we're looking 275 hours is a realistic number because I just know a lot about this stuff and I can get in and absorb a lot quickly. Certainly would prefer having the freedom to run over that if it turns out it's more complicated than I anticipated or some of the studies supporting this are more complex than I was expecting. But that's a reasonable ballpark number. Clearly, you'd have some cost savings on a per proceeding basis if you hire the same firm for all three. But there's still it's going to be more work. It's not like you could do all three for the same amount of hours. I would say maybe a budget of 500 hours would be plausible for all three. I would certainly prefer having the freedom to work more hours if it turns out that's what really is required to do a thorough job. But to the extent if you want my best estimate right now, I'd say assuming a tight time frame, there's a limit to how many hours we're going to put in. We have other obligations. Something like 500 hours over a tight time frame for all three would be a reasonable number to think in terms of.
Okay, thank you. So if I heard you correctly earlier, you weren't aware of the timeline, but you made the statement the more time is better. And I think I heard you say that 10 to 12 weeks would be the absolute minimum amount of time required.
Yes, but that includes not just preparing the report, but also, the additional work that I think you're now visualizing, where after the report, there's an opportunity for the parties to either depose or cross-examine or some sort of a process that's a little more elongated than you had last time around. So that to me is the minimum. And it would be, again, better if you're able to add more time. And it better in the sense that you have more information to work with, and you pretend like with a little more time, it might be possible, for example, to include as part of the report, if that's what you wanted, suggestions for issues to be explored in future proceedings. Sometimes I've seen that can be helpful to a commission because they discover something is interesting and they would like to know more about it, but none of the parties are prepared to give a full answer at that time. And you still have the press of business. You've got other issues. You need to resolve that proceeding. And these proceedings tend to roll on. The statute certainly contemplates that every year or two, or whatever it is, there will be more filings in the future. If you wanted the consultant to talk about that, maybe as a part of their report or after, wherever you wanted it, building in an extra couple of weeks worth of time for the consultant would be helpful to you if you wanted that.
Let me give you a hypothetical then. If you were asked to perform this service for all three, could you do it in 12 weeks?
Yes.
And you estimate if you did all three, plus or minus 500 hours, around 500 hours approximately.
Yes.
Okay. And you mentioned, and I think you clarified that, you do not do the modeling, you evaluate the modeling the utility provides, I guess for accuracy or for questioning or whatever, any modeling required, looking at, I think you said hourly evaluations and the, I guess, weather conditions. Is that correct?
Let me back up and clarify just a little bit, because one way of thinking of it is there's two pieces to the tariff. There's a capacity piece and an energy piece. We do have in-house the ability to do the capacity portion independently using our own model. I do not expect to see substantial differences between the output of our model and either Dominion's or Duke's model, assuming you put in the same inputs and assumptions. But we used our own model enough that gives me added confidence that, and if I did start seeing differences, it would give me the insight to go back and try to figure out why would their model now give me something different than what we do. That's on the capacity side. The hourly energy is where, and we can also, on an annual basis, we can model energy. So I just want to be clear about that. But the problem with energy is it tends to be and needs to be priced on an hourly basis, just in some manner, seasonal, time of day, whatever. So that's where our abilities sort of fade out, and we have to rely on running or modifying the utilities modeling if you want different answers. For example, if you were interested in a scenario in which gas prices are increasing in a different pattern than what the utility assumed, we have some ability to model that on an annual basis, but to bring it down to the hour basis independently. But to bring it down on an hourly basis, we would need to rely on the utilities model, or you would have to have another consultant that has software capabilities that we do not have in-house for the hourly.
Sure. So I want to make sure I'm understanding how it works. To acquire most accurate avoided costs, are you saying, or do you agree that it would require hourly data, weather information and such, so that an as accurate as possible determination of what the costs are relative to, say, whether it's a QF with dispatchable energy or one that is intermittent? Does that make sense?
Absolutely makes sense. And you're absolutely on the right track. So the hourly pattern of demand for electricity is very important in understanding the cost. It's even important for understanding the cost on the capacity side, which is where we have the full in-house capabilities to do independent modeling if that's your desire. But the hourly pattern is particularly important on the energy side, which are now changing over time as different weather patterns emerge. Some people's demand is being not being pulled off the grid because they're relying on solar, but solar has some very distinct patterns. If you've got rooftop solar, on some of these homes or businesses that's shifting that net demand that the utility is having to meet. So for all those issues, as well as the issue of interfacing with neighboring utilities and the like, hourly detail needs to be dealt with in some manner. You cannot just gloss it over the whole thing and have a single rate based on a year-round price. If you're going to offer a rate and a tariff that could potentially be applicable to anything from a solar company, which have different technical characteristics. So you can't even simplify down solar, say, well, here's the solar profile. Well, that can vary depending on how they designed their solar facility. But certainly if you're talking about cogeneration, which is where industrial processes send off excess heat, and that heat is used to produce electricity. It's very efficient and it's encouraged by the PURPA. The pattern of that needs to be responsive to when the utility needs it, because the industrial process may be a 24-hour a day process, in which case, that pattern is what it is. But in other cases, the industrial client can adjust the amount of what's called a host. The host process, the industrial process, may be concentrated at night, for example, normally, but then because of the ability to sell energy, they might decide, oh, well, I guess I'll produce some of this during the day because I'm paid more. So again, the price sensitivity by hour is applicable to a wide range of things. It's an important issue.
So it sounds like you're talking about if you're looking at different rate classes or different, I guess, demands from the particular class or entity or whatever it is.
The solution that historically this commission has used, and many commissions have used, is to establish seasonal price differences and also some sort of time of day price difference. Typically, that time of day was pretty simple. It was on peak, off peak, and that was sufficient for many, many years. It's become less sufficient in recent years for a variety of reasons. I'm happy to delve into it, but I don't want to overrun my time. But moving towards more granular time of use calculations is one of the solutions out there that has been happening. And in North Carolina, for example, they had a proceeding a couple years ago I was involved in, and ultimately I believe it was settled and resolved that they would move towards more granular. Instead of just 2 time of day periods, they have several time of day periods and a more sophisticated way of looking at the seasonality as well.
Thank you very much, Dr. Johnson. I appreciate it. No more questions, Madam Vice Chair.
Thank you, Commissioner Caston. Other commissioners? Dr. Johnson, I have a question for you. You mentioned possibly that it may be beneficial to the commission to have 2 firms collaborating. If that is something the commission would consider, is that an arrangement that you would be willing to participate in?
Oh, absolutely. Okay. Absolutely. And whatever way you want to structure it is fine.
Dr. Johnson, this is a very compressed time frame, and while the statute doesn't set a specific date, the first avoided cost orders had to be, or the decision had to be made by November 16th, and then subsequently it says at least every 2 years thereafter. So we're looking at a November 16th. We've got hearings scheduled in August, so we are under a very compressed time frame. Just for your information. So.
Okay. Thank you.
Dr. Johnson, thank you for your time this morning. Thank you for all the information you have provided. Commissioner Chairman Williams, did I skip you? I apologize.
No worries. I just wanted to relate to Dr. Johnson that I appreciate his situational awareness.
Thank you. And again, if you have any other questions and want to schedule another follow-up interview of any sort, I'm more than happy to do that. And I also want to make clear that whatever mechanism you ultimately decide, if you decide it's appropriate to allow your consultants to collaborate with each other, whatever guardrails you put on that process is perfectly fine with me. I'm sensitive to the ex parte issues in South Carolina and the importance of setting this up right. And more than happy to work within whatever system you ultimately decide is needed. Thank you.
One last thing, Dr. Johnson, we will be sending out the list of parties in these dockets this afternoon. A final conflicts letter is due. I think it's close of business on Friday, at some point on Friday. So we will make sure we get those out this afternoon so that y'all can submit that final conflicts letter to us, if you would.
Okay, thank you.
Thank you, sir, and I hope you have a good day.
Okay, bye.
Bye-bye. We need to recess to reset for the next interviewee. So let's take 10 minutes. It is 2 minutes after 12, so we will return at 12:12. Thank you. Good afternoon and welcome back to the Public Service Commission as we continue with our discussions and interviews with prospective consultants for the commission in these avoided cost dockets. Let's take a roll call of commissioners. Virtually, we have Commissioner Caston and Commissioner Irvin. Chairman Williams, are you on the line?
I'm here.
Thank you. And in the hearing room, we have Commissioner Thomas, Commissioner Powers, Commissioner Carolee Williams, and Vice Chair Belser. And we've got a roll call complete, and our next interviewee is from London Economics International, LLC, Mr. Goulding. Ms. Mueller, are you with us?
Yes, we are.
Thank you. There you are. Good afternoon. The way we are proceeding this morning, if you would like to take 5 to 10 minutes to give us an overview of London economics and your proposal, and I believe you were sent some questions that the commission is interested in hearing some answers to. If you want to touch on any of those during your opening, that would be appreciated. Otherwise, we'll follow up when you finish.
Great. First of all, thank you so much for the opportunity to present the qualifications of my firm today. London Economics International has been in business in the U.S. Since 1996. The firm focuses on economic and financial consulting to the energy and infrastructure industries. The firm prides itself on being focused on analytics. The firm is not an advocate for any particular position. And the firm has clients across the regulatory, utility, private equity, developer, and civic institution space. While the proportion of work varies across those, roughly speaking, normally about a third of the work is for utilities, about a third is for regulators, and the remaining third is divided across financial institutions, civil society, such as both industry and environmental groups, and other kinds of institutions. Our firm consists of economics and financial experts. We are not lawyers, nor are we engineers. The firm has significant capabilities with regards to modeling of electricity markets. The firm approximately every 6 months updates its models for all regions of North America except for Mexico. And that detailed modeling uses proprietary tools, including production cost modeling. And in the process of performing that modeling, a significant amount of time in those regions of North America where there is not an independent system operator or a regional transmission operator, a significant amount of time is spent reviewing integrated resource plans and coming up with an understanding of avoided costs in particular regions. The firm also has significant experience in reviewing and drafting power purchase agreements. It has done so not only in the U.S. But overseas, including across the Middle East. But in the U.S., PPAs that it has drafted or reviewed include in California, Vermont, and Maine. In some cases, those interactions included negotiations between off-takers and utilities with regards to avoided costs. If it makes sense, I can go through some of the questions that were asked here. and give you some responses, and then open myself up for further questions. So we have not, the firm and myself have not appeared before the commission in South Carolina. The firm has not been retained by Duke. With regards to Dominion Energy, the last time that we had an engagement with an affiliate of Dominion was in 1998, 1999, where we did some strategy work for Virginia Power. We have not been retained to represent IOUs in South Carolina. To the best of my knowledge, no members of my family, partners or associates own stock in Duke Energy or Dominion. I have no reason to believe that I cannot serve or that the firm cannot serve as a fair, impartial, and independent consultant on any of these dockets. We do not have ongoing business dealings with any of the parties to these dockets. And we are not currently in negotiations to represent any of the parties before the commission. With regards to my own qualifications, including holding a master's from Columbia University, I also teach electricity markets at Columbia University's School of International and Public Affairs. I have done so for approximately 15 years, as well as overseeing graduate workshops and authoring publications through Columbia's Center for Global Energy Policy. I am not, aside from the Ontario Energy Network and Ontario Energy Association, and the Ontario and Alberta industry associations, I'm not a member of any other utility-related trade groups or organizations. Happy to provide a written proof of conflicts from the firm. We understand the ex parte rules and will abide by them. Now, you asked a few questions with regards to the schedule, estimated hours per task, and the estimated total costs. First of all, we would work closely with the commission to align our schedule with the commission's needs. We understand that proceedings are starting quite quickly here, and that our work would need to commence in parallel with the proceedings.
Mr. Goulding?
Yes.
I'm sorry to interrupt you, but I did just want to caution you, and this is a public forum here, you may not want to discuss specific pricing here for competitive reasons, but just didn't want you to get into that realm right now, okay?
I greatly appreciate the caution, and my objective here is to be as efficient as possible. If my approach of running through the questions that you've asked is not efficient for you, please do let me know, and I will skip over those questions for now. I guess before proceeding, is this an effective way for me to utilize your time?
Yes, sir. I just didn't want you to get onto that one question about the pricing. That was all I was trying to caution you about.
No, I greatly appreciate that. You've asked some questions about what information the commission needs to receive from our firm with regards to avoided costs. And I think that ultimately you need to have confidence that we have independently reviewed the submissions of the utility or utilities. And we need to provide you evidence of that. And so the way that we would generally go about this is we would first summarize the process that the utilities used in their submissions. We would highlight key assumptions and test them for reasonableness. We would then determine whether the results that the utilities have provided are consistent with what we would expect to occur using those assumptions. And if there are anomalies, we would want to test those further. And that can go down two different paths. We have our own, as I've said, sophisticated dispatch modeling tools that we can use to replicate what the utilities have done. And we can also ask the utilities to rerun using different assumptions if we feel that their assumptions are not appropriate. And I think that we will likely want to pursue both paths in order to provide confidence in our opinion with regards to the avoided cost submissions of the applicants. That's not to suggest that there's anything necessarily wrong with what the utilities have submitted, but we do want to take a thorough approach to, in particular, testing the assumptions, because anybody's models are only as good as the assumptions that you put into them. So our firm does not contribute to political action committees, nor do I. No one in our organization has worked for a public utility or solar company in the past. We do have some former employees who work at public utilities and solar developers. We also have former employees who work for regulators. And there's nobody associated with our organization who has any affiliation with a public utility or solar company. Now, moving to your subject matter questions. As I've mentioned, we do have experience in drafting power purchase agreements. Those have generally related to biomass, hydro, and solar. As I mentioned, they include California, New York, Vermont, and Maine, as well as our work overseas. We have not drafted commitment to sell forms, but we have the capabilities to do so. Now, our experience in thinking about avoided costs and avoided cost methodologies is extensive. It's perhaps a bit different than some of the other folks that you'll be considering. All of our modeling involves thinking about the marginal resource. That is, what is the next resource that is required to meet load? This has become more and more complicated as uncertainty about load projections has increased, and as the resource mix has become more diversified, as well as having new types of resources like demand response become more available. And I emphasize that I'm speaking broadly here, not specifically to the circumstances of South Carolina. But all of the modeling that we do involves the same calculations that are necessary to calculate avoided costs. And our models allow for the type of with-without analysis that is the basis for the Peaker methodology that is referenced in the applications and in the neighbor handbook. Now, in addition, we have worked with a number of PPA counterparties, both in helping them to understand avoided costs, in some cases provide projections in PPAs that required a reset of avoided costs. Another area where calculations similar to avoided costs are necessary, an increasing amount of our work relates to looking at non-wires alternatives or non-transmission alternatives. And that requires thinking a great deal about what the alternative resource looks like and what its costs are. So much of our energy transformation work incorporates avoided costs, and this time frame is quite recent. Because expert testimony is a regular part of what we do. We do have experience drafting data requests or discovery. In our proposal, we gave some examples. But the most recent example is related to a case before the Ontario regulator, the Ontario Energy Board, involving the equity thickness for a provincial generator. But I'm involved with both private litigation and regulatory matters, usually 3 or 4 times a year. Not all of those involve drafting data requests, but many of them do. And the firm has done this across multiple states and provinces. The competencies of the team, and the team is not just Stella and myself, but we have an extended group in Boston and in our other offices, which has capabilities to both review testimony, review IRPs, calculate avoided costs, and run models. Almost everyone in our organization has the capability to run the models and to perform this kind of work. So the depth of our team, we can draw on more than 20 individuals with relevant skill sets. You've asked a bit about process competency. And what's important in doing things in parallel is that in your analysis you have an adaptable framework, because you're going to be trying to perform the analysis based on everything that's been submitted to date. At the same time, you're going to be monitoring testimony. New things may come up in testimony. And so when you start building both the templates for your written work, as well as any modeling, you want to make sure that as much as possible you can simply change a number in a cell when new information becomes available through the hearings. And so we would be monitoring the hearings, quickly highlighting anything that would impact our analysis, but our analysis is not going to be waiting for that particular nugget in order to proceed. And so we have significant experience in listening to testimony, both online and in person, doing daily internal summaries, highlighting key areas of importance, and as well, we have an established framework for writing reports. What we attempt to do is to make documents as user-friendly as possible, including a one-paragraph summary up front, a one-page executive summary at the beginning of the document, and then making sure that each section has a paragraph summary at the top of that section. So we give a great deal of thought to the way that we organize our documents, and the intent is to make them user-friendly. And so sometimes that means we may need to put details into an appendix or to do other things so that you can balance between being comprehensible and comprehensive. But our reports are designed to be easy to use. We're used to working on projects with challenging schedules. And so while with any project you always wish you had more time, ultimately we work with the time we have to produce documents of high quality. And so we will, if we were to win this work, we would adjust our resourcing accordingly to make sure that we met the timeline. Now, you've asked about the benefits of awarding all contracts to us versus the benefits of awarding only one contract. And I think regardless of who you choose, I think that the trade-off you have to consider is that if you award all the contracts to one firm, you can expect that they're going to be consistent methodologically. You're not going to have multiple reports that use the same word and mean different things. And you're likely to achieve some cost efficiencies. Now, in theory, if you were to award one contract to each firm, you might have some timing benefits, but I'm not certain that by the time you start trying to put all of the reports on an equal framework, making sure that that they are saying the same thing when they use the same terminology, I think you may end up losing that time. So certainly, completing one contract means that you might be able to get it done sooner, but I'm not convinced that there's a whole lot of time savings there. So as I've mentioned, we have been deposed, we have been cross-examined, and we have testified. Let me now turn my attention to the questions on methodology and modeling. We do have the ability to replicate the modeling in-house. Now, that said, we would utilize our proprietary tools. If you want to exactly replicate the modeling, then you have to get a license to exactly the same software that was used by the applicant. That's doable. That's probably not cost effective or time effective. And so I think that what we would do is we would use our internal modeling tools to identify potential anomalies, look at the source of those anomalies, and then use that to determine the types of things that we might ask the utility to run. So we have to be mindful that, you know, the best modeling tools with dispatch algorithms, when you put them side by side, they're going to produce on average similar results, but in specific circumstances they're likely to differ, and we have to recognize that limitation. So we would not plan to outsource any modeling. And because we've developed tools internally that we use to check results that come out of our models, we can develop similar tools to assess the results that come out of the utility models. The first step, simplistic as it sounds, is to go back over the assumptions and make sure that what was input into the model is actually what you have in the assumptions sheet, and to check just simple things about whether a decimal has been missed, or let's say a particular fuel track has been misplaced. Things like that help us to audit modeling that's done from others. Now, I believe that this completes the questions from the Commission. In looking through the questions from the applicants, I believe they are, for the most part, related or similar to questions that I've already addressed. So perhaps it's best for me to pause here and listen to any other particular issues you'd like me to address.
Thank you, Mr. Goulding. Let's see if any of the commissioners have specific questions for you. Commissioner Carol Lee Williams.
Thank you, Vice Chair Belzer. Mr. Goulding, thank you for that great rundown of how you would approach this. My only question has to do with Ms. Mueller. Would you describe kind of the roles that you will play and she will play, and if there are any others that will also participate? We've gotten a good glimpse of your capabilities and background. If you could add to that what Ms. Mueller's background is and the role, maybe even percentage time-wise. What are you going to do? What's she going to do overall?
That's a great question. I suspect the reality is that we will run with at least a two-person team. And so my role is to lay out the work and to provide the work plan, to identify the resources, to then check that the work has been done properly, and to ultimately develop the conclusions. Now, Stella has familiarized herself with this docket. In fact, she was the primary author of the proposal. And in addition, has had experience doing things like reviewing IRPs in the context of pulling together some policy advice. Did that for an organization in Indiana, for example. So she's familiar with all the various documents that go into this. She would be running any model that we would be deploying. Generally, the way that our modeling process works is that there is the modeler, and then we have a centralized review process for modeling results. So there's another senior person in our organization who would review the results. Then in addition, we would likely add a team member that would help Stella and myself with research or with reviewing particular dockets or looking through for modeling assumptions. I think, generally with these kinds of engagements, if you make the team too big, you start to get inefficient. But I think that the right approach here is for me to lay out the work, identify the issues, the areas of particular research. We will likely rotate responsibilities for listening in on the various proceedings. We'll have some kind of a standardized reporting format internally for that so that we can rotate around. Does that give you enough idea? I think you'd also asked about percentage. To a certain extent, that depends on the duration of some of the proceedings. Roughly, I would say that I would probably account for maybe a third of the hours. Stella would account for maybe 50% of the hours, and then an additional resource would account for the remainder of those hours.
Thank you very much. Thank you very much for that thorough answer. No further questions.
Any other, Commissioner Thomas?
Thank you. I was just wondering what your feelings are in connection with actually working with another consulting firm. You did mention the awarding to different firms, but I don't believe I heard you talk about the possibility of working with different firms. Is that a possibility?
Well, we've certainly done it in the past, and I think that first of all, I want to emphasize that that there's lots of strong professionals here. I know and have worked with at least one of the other applicants, and I'm confident that we could work well together if that was the route that you felt made the most sense. I mean, the challenge is coordination and frankly, egos, right? And if all of the consultants kind of check their egos at the door and focus on the work product, it can work. But I think it requires upfront coordination. I think if I were you and I were considering doing multiple consultants, what I would try to do is force them to come up with a set of common assumptions that would guide their analysis so that the consultants up front would agree on, and I'm just giving you examples here, whether it's natural gas prices or come to a consensus on what peaking technology you would use and the source of the capital costs, maybe discount rates, but we've certainly been in situations where we've had to work with other consultants on working on parallel paths. And if that were the direction that you decided to go in, we would work hard to make it successful.
Thank you. I appreciate that. That's all I had.
Thank you, Commissioner Thomas. I heard someone on either phone or
Vice Chair Belcher, this is Commissioner Caston. That was me. I would like to ask a question, if I may.
Certainly. Go ahead, Commissioner Caston.
Mr. Goulden, good afternoon.
Afternoon.
For all three utilities, if your firm performed this work for all three utilities, do you have an idea, rough idea of what the estimated man hours would be?
I do have a rough idea. It's subject to particular assumptions. When we looked at it, I thought that a reasonable assumption would be approximately 200 person hours for the first one. I think that doing them all three together, you'd probably have some efficiencies. So you might end up, let's say, averaging, call it 170 hours per. So you would end up with 600 hours, 600 person hours on all of them. I think you'd probably end up at maybe 400. I mean, that's 10 person weeks. That's how I see it now at a high level. There may be some further efficiencies that can be gained there.
So you think if your firm did all three of them, you probably in that 400 range, and 200 hours apiece if they were done individually. Is that what I've heard you say?
Yeah, I think if we did three, we'd be at above, we'd probably go above 400 a little bit, but I think I always get myself in trouble in these kinds of estimates because things turn out a little bit differently. But yeah, I think that's the ballpark range.
I understand. And as far as time frame, you think you could successfully accomplish this in 12 weeks or less?
Yes. Yeah, I don't think 12 weeks is an issue. That, if you told me you wanted me to start tomorrow and finish it in 2 weeks, I would have challenges. But I think that time frame is reasonable.
Well, that was my next question, to see if you could do it in 2 weeks, but no, it really wasn't. That's all I have. Thank you very much, Mr. Golden.
Thank you, Commissioner Caston. Any other commissioners? Hearing no more questions, Mr. Goulding, is there any? Commissioner,
Madam Chair,
Commissioner Irvin?
just one question. Do you have any familiarity with Act 62 in South Carolina? Familiar with that?
Yes. I mean, I should say we are familiar with it in the context of preparing the proposal. We have not done any work. We haven't testified on it. So our familiarity is only in the context of preparing the proposal.
All right, sir. Those are all the questions I have. Thank you.
Thank you, Commissioner Irvin. Any other commissioners? Mr. Goulding, it doesn't sound like there are any other questions. Do you have anything else you want to say in conclusion?
No, I just want to thank you for the opportunity. And I know you have a difficult task, and I'm sure to the extent that you think that we would be a good candidate, we would be honored to have the opportunity to work with you.
Thank you. Mr. Goulding, we do have a final conflicts check letter that we will be asking for to be filed this Friday, I believe, by close of business. That time may be off, but there will be an email sent this afternoon with a list of all parties to these dockets just for that final conflicts check to make sure that everybody is clear of conflicts. So be on the lookout for an email this afternoon. You or Ms. Mueller.
Thank you.
Thank you very much. We appreciate your submittal and your time today. Thank you. With that, we're going to recess the hearing. We do need to reset. I think our next scheduled interviewee is at 1:45, so we will return at 1:45, and we are in recess until then. Thank you.